Already? Good morning. All right. Sorry for the delay. Dislocating being here in 4C. We've got a final plea calendar that started a few minutes ago. I've got a couple pleas, I believe, from the competency docket. I see Ms. Gordon here. Is Ms. Sellers? Great. Do we have Barnes and we'll wait for Deputy Gordon.
Yes.
Barnes and McBride are here?
Yes.
Okay. And are those ready to go? Do you need to chat with your client?
I spoke with them both yesterday, Your Honor, we're ready.
Thanks. I'll weave those in. We'll do them early this morning. And then we've got the presiding bond calendar that I'm not late for yet. That hasn't started yet. So what I'd like to do is call the final plea calendar to see what we might be doing with some of the cases. And then if there are pleas, we'll sort of get those in the queue with the 2 competency docket pleas. And then we can hear some of the bond cases as well. So, final plea calendar, for those of you in the gallery, if you are on for final plea, this is the last day you can enter a plea and have the ability to withdraw your plea if the sentence you get is different from what you asked for. So if you ask for 3 years probation through your lawyer and I give you 4 years probation, that's a worse sentence. You could say, no, thank you. But you'll have a chance to talk to your lawyer about it and say, all right, I'd rather have 3 years probation, but I'll take 4. And if you decide you don't want to do that, no harm, no foul, we just move your case to the trial calendar and you'll get a trial. After today, you can enter a guilty plea, but you would not be able to withdraw your plea if you didn't like the sentence that you got. That's the main change. Positions 1, 2, and 3 are all Mr. Suttles. Is he here? He is. How are you, sir? All right. And your lawyer is on the screen and I'm going to put her right there. Oh, walking in the parking deck.
I'll be there soon, Judge. If we could hold. I talked to Mr. Suttles yesterday. I need to talk to Ms. Nix, and then I'll have a better announcement for the court.
Sounds good. Okay. So Ms. Wood is working her way here. She's in the parking deck literally right across the street. She's going to come on in. She's going to want to talk to you. It sounds like she got a new offer from the prosecutor, Ms. Nix. They'll talk a little bit more and we'll see. Maybe we can resolve your cases today. So I need you to go back, take a seat. You know, you've met Ms. Wood before. You'll recognize her when she comes in. She'll want to talk with you and maybe we work this out. You got 3 pieces of business to work through. Okay. All right. Thank you. Michael Reynolds in custody. That's also a Ms. Wood matter. Ms. Nix, any idea what we're doing with that?
Good morning.
Oh, hey.
I'm ADA Joya Rutland. An offer was sent yesterday, but we haven't had a chance to discuss it.
Hi, Joya Rutland. Why is this your case?
It is flagged as a hate crime.
Oh, okay. All
And
right.
Judge, I will, I need to just convey that to Mr. Reynolds. And so I'm hoping to resolve this case today.
Great. So Mr. Rutland is here and up, and when you get here, you can meet with him. Thank you for the new offer. I just got assigned a new case. Will that be yours? The guy who pooped on the flag?
Yes. That would be
Okay,
mine.
that'll be yours.
Yes.
All right. I think there's a warrant out for him.
Yes, he's
Okay.
in Pennsylvania.
All right. I look forward to meeting him.
Thank you.
So we'll see what happens with Mr. Reynolds. Charles Ellison. Hello, Mr. Ellison. Your lawyer is Mr. Fortis. Any idea where he is?
At the moment.
All right, you're gonna be working on calling him, right? And let's see, Ms. Nelson, if you would, she may be sending me a message right now. Yes, she's holding for his report. So he should be here this morning. We'll see if we get an ETA. And you'll just need to sit tight. You're welcome to text him too, saying, man, I paid you, where are you? And we'll see when he gets here, okay? Ms. Nix, had you and Mr. Fortis had any communications? You've sent him info, you're waiting to hear back from him?
I had previously sent him an offer and he texted me after hours last night to call him and I have not done that.
Okay,
So
he'll be here. We'll discuss. All right. Cynthia Honholt.
And she's in custody.
that's Ms. Wood as well.
Okay, and so she's not here or she's downstairs. All right. In custody. All right. Divinity Rivera. Hey, Ms. Rivera, your lawyer is in trial right now in this building and she sent an email. It looks like maybe we're thinking about diversion for Ms. Rivera.
Yes, sir. I have referred it. I've not heard back from the Virgin, so that's what we're waiting on.
Okay,
I'll,
can we reach out to see, or you referred it yesterday and?
I referred it last week.
Okay, I know sometimes they take a little bit, but if you just check with them, because if we learned while Ms. Rivera's here that she got in, that's just good news. Has your lawyer talked to you about what diversion is, Ms. Rivera? So I'll just give you a little thumbnail sketch. It is an opportunity for a few months, you do a little community service, you might have to write a paper or something like that. But if you do those things, they dismiss your charges. And to qualify, you can't have been in trouble before like this and all sorts of, there's certain things, but it sounds like your case may fall into that category. And so your lawyer, Ms. Cabrera, had asked that Ms. Nix think about that. And Ms. Nix, the prosecutor, did and has asked the people who run the program, they just need to figure out if it makes sense for you to be in that. So I'm gonna ask you to stay a little bit longer, just so we can hear back from the program to see if they've decided yet. If they haven't decided yet, then I'll let you go, because as I said, your lawyer is stuck downstairs doing a murder trial right now, okay? Thanks. Mr. Williams, we'll come back to him. Ms. Peterson, how are you?
Good, how are you, Your Honor?
I don't know if you got a copy of it, but someone wrote for him a nice letter that says, I don't like my lawyer or my judge. And so we're gonna work through that briefly today.
Absolutely, Your Honor. I
Okay.
did not get a copy of that, but I.
Okay, well, I'll give you a copy. You have my copy when we're done. I mean, I can't remember if it's in the docket or if I think it was sent to chamber, so
Okay,
it
so
didn't
not-
hit the
not
docket,
filed.
but you're entitled to it. And we'll talk with Mr. Williams about that when Ms. Wood is here. I did rule on the 413. You should have received that.
Yes, Your Honor, I did receive a copy.
Okay.
Thank you so much.
All right, Mr. Gomez. Ms. Nelson's gonna send you a copy of the letter.
Okay, thank you so much, Your Honor. And
Um,
also-
Mr. Gomez, I can talk to in a minute. How about Duranta Jones? We'll wait for Ms. Wood to get here to see if she's got a report on him. Okay. While we're waiting on Ms. Wood, then, if you don't mind pinging your diversion folks, and maybe you already did that, why don't we do one of the pleas from the competency docket? And then let's make sure we've got lawyers here. I don't know who's gonna be arguing. We have 3 bond motions. Alana Fields. Are you handling all 3, Mr. Rao?
Yes, sir.
Okay, so we have someone from the state. Samantha Beck is the name. I assume that's someone from the public defenders. Hey, how are you, Ms. Brevik?
Good.
Are you gonna be handling the bond motions? Or,
Figure that out.
okay, it's not till 9:30, so no one's late yet. I just was sort of taking attendance. So we've got Ms. Fields, we've got Ms. Rasheed, and Mr. Yisrael. And they all list Samantha Beck, so we'll figure that out. Okay. Anyone here didn't hear the name of the person they're here for, call, because that should be everything we've got this morning. All right. Why don't we do Mr. Barnes? I'm happy to do either one first. Just looking at where they're housed, I thought maybe we do Mr. Barnes first.
Sure.
Okay, can we bring Mr. Barnes out?
Yes,
Can I
sir.
guess the table and the podium?
I would like you to be wherever you're comfortable. Courtroom, especially if you use the microphone, there is no trouble having Ms. Rivers hear you. So if Mr. Barnes, you think will do better at the podium, let's be standing. If he'll do better sitting, then let's be sitting. You're the one who knows
We'll
that.
sit, Judge, I think he'll be fine though.
Okay. Ms. Sellers, you should not be shy and stay in the back. You should come on up. And you're welcome, if you want to be at the witness stand, you can do that. You can take a middle seat at the prosecution table, wherever you want to be.
Space.
How are you? What are you here for? Oh, you have this?
Yes, sir.
Okay, I'll be looking at this while we're working through our stuff. But I also wanted to try to figure it too, just ask him officer.
Oh,
You're
thank
good.
you. I'm doing well. Good to see you, Judge.
You're okay? Yeah.
Give me a sheet.
You can just be like print your paper.
You don't play them.
Hmm?
You just don't play them. I'm trying to get home.
That's exactly. We're all set. Everything we talked about yesterday.
Work.
Just, this is, Ms. Sellers over here is the prosecutor. She's gonna ask you a bunch of questions. Just answer her questions. If you have any questions, if you don't understand her question, just let me know and I'll help you through, okay?
All right, and then I might go to the group.
You're gonna go on,
In 1 second.
October 30th.
No.
Next week, you're gonna get the sheriff's office is gonna transport you to Homes
Is
of
that
Light.
anybody we can help with?
I can ask, but the transport order is already done for that day.
Green, are you doing the final disposition?
These are your two cases.
Paperwork.
This case.
Great,
you're charged with
because Ms.
criminal damage and the
Nelson
second
just asked me,
degree
am I
civil
supposed to be doing
battery.
it? You got that? Great, thank you.
Drinking and driving while license suspended. We're gonna plead
All right.
on both
Are
of
you ready,
these.
Sellers?
I'm ready. You're gonna sign your name right above on the line where it says defendant, right above where I sign mine.
I don't care.
Hmm?
I don't care.
You can look wherever you're comfortable. When you're speaking, or just look into the microphone, okay?
Are we good?
Yeah, Judge.
All right, well, let's get on the record. This is 24 SC 000296, State versus Johnny Barnes. Hello, Mr. Barnes.
Oh,
I'm Judge McBurney. It's nice to meet you.
nice to meet you.
Mr. Barnes, your lawyer has told me you're ready to enter a plea in your case. Is that right?
Yes, sir.
Okay, Ms. Sellers, who's the prosecutor in your case, she's standing up over there. She's going to ask you some questions. You need to answer the questions as best you can. If you have questions at any time, let Ms. Gordon, your lawyer, or let me know, okay? If you
Okay.
can't hear or if it's confusing, just tell me and we'll work through it, all right?
All right.
Good. Ms. Sellers, when you're ready.
Thank you, Your Honor.
And he actually has two cases on the calendar,
Oh.
or two cases
Two cases,
we
okay?
are resolving today. The second case is 23 SC 189154.
154, all right. Okay. When you're ready.
Okay. And would you please raise your right hand? You swear or affirm that the testimony that you will provide to the court today will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
You may place your hand down. Please state your true and correct legal name.
Johnny Lee Barnes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Just, my medication.
Okay. And does that medication that you are taking today, does it affect how you are able to perceive the proceedings today?
No, ma'am.
And is there any medication that you are normally given that you have not been given today?
No,
How old are you, sir?
55.
And how far have you gone in school?
My GED.
And you are able to read, write, and understand the English language.
Yes, ma'am.
You understand that you are being charged with the following offenses. In 23 SC 189154, you are being charged with criminal damage to property in the second degree and simple battery. And in 24 SC 000296, you are being charged with theft by taking and driving while license suspended or revoked. Do you understand these charges that you are facing today?
Yes, ma'am.
You understand that you have the right to plead either guilty or not guilty to these charges. And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
And I have your signature on both of these indictments. Is this your signature on 23 SC 189154?
Yeah.
And is this your signature on indictment 24 SC 000296?
Yes, ma'am.
Your Honor. Can do these indictments.
Thank you.
Have you had enough time to speak with your attorney, Ms. Gordon, about all of the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
Yes, ma'am.
And do you need any more time to discuss this case with your attorney?
No, ma'am.
And are you satisfied with your attorney's services today?
Yeah.
Counsel, do you waive formal reading of the indictment?
Yes,
Do you waive any and all defects in the indictment?
yes.
And Mr. Barnes, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading to today?
Yes, ma'am.
And so you understand that in indictment 23 SC 189154, the charge of criminal damage to property in the second degree carries a sentence of 1 to 5 years. And the second charge in that indictment, simple battery, carries a sentence of up to 12 months.
Yes, ma'am.
And that minimum and maximum sentence.
Yes, ma'am.
And do you understand that in indictment 24 SC 000296, the charge of theft by taking carries a sentence of 1 to 5 years? Second charge in that indictment, driving while license suspended or revoked, carries a sentence of up to 12 months.
Yes, ma'am.
Do you understand that if you're not being sentenced as received? Do you understand that this is a negotiated plea? That means that your attorney, Ms. Gordon, and I have discussed this case, and we are presenting to the court a recommended sentence of 5 years to serve 2 years. And those 2 years are reduced to the time that you have already served. And a condition of your probation, that is 3 years probation, is that you are in the Brady intensive case management and remain, and you will be transported to homes of light. And defense counsel can explain that a little bit more, but that is the recommendation to the court. And you understand that the court does not have to follow this recommendation and can sentence you to the maximum available to the court.
Yes, ma'am.
Do you understand that it may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole, no matter what anyone has?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? And I will go through a list of those rights. The right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you understand these rights that you are giving up today? Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
And it is your decision to waive these rights and enter a guilty plea because you are in fact guilty.
Yes, ma'am.
How do you plead to the charges of criminal damage to property in the second degree and simple battery in 23 SC 189154?
Guilty.
And how do you plead to the charges of theft by taking and driving while license suspended or revoked in indictment 24 SC 00296?
Guilty.
And are these guilty pleas freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
And do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for the felony charges and 12 months from today for the misdemeanor charges to file a habeas corpus petition challenging the voluntariness of these guilty pleas?
Yes, ma'am.
At this time, Your Honor, the state will in this case. For 23 SC 189154, if this case were to go to trial, the state would prove the following facts beyond a reasonable doubt: that on January 15th, 2022, officers were dispatched to a call at 1801 Howell Mill Road in Atlanta, Georgia, in Fulton County. A white male was walking down the parking lot, hitting objects and people with a stick. There were multiple 911 calls, all describing the same incident and the same suspect. Officers met with Jamal Williams, whose vehicle was damaged, and Amy Wright, who was struck with a stick. The defendant, Johnny Barnes, attempted to run away from the officers as he was approached. After a short pursuit, he stopped and surrendered, and he was placed into custody without incident. And that completes the facts in that indictment. An indictment 24 SC 000296. If this case were to go to trial, the state would prove the following facts beyond a reasonable doubt: that on March 2nd, 2023. Multiple units were canvassing for a stolen vehicle, a green 1997 Ford F-150. The owner stated that he parked his green Ford F-150 in front of the location of 99 Dahlia Avenue, Northwest Atlanta in Fulton County. The victim, Myron Johnson, had surveillance video of an older white male wearing blue jeans, white shirt, and a blue jean jacket with a black hood come from the front porch and walk to the green pickup. The victim stated that he left a spare key to the vehicle behind the front driver's seat. In the video, you can see the white male get into the front driver's seat and after a few moments drive off with the vehicle. This occurred around 4:54 p.m. on that day. Officers were then able to locate the vehicle parked near the intersection of Sanford Drive Northwest and Perry Boulevard Northwest in Atlanta in Fulton County at approximately 8:00 p.m. They were able to confirm that this was a stolen vehicle based on the tag GCY 342. The vehicle then turned and reversed out of the parking space and a traffic stop was conducted on the vehicle. The driver was later identified as Mr. Johnny Lee Barnes and was in the front driver's seat and then was detained by officers without incident. The driver of the vehicle matched the description of the white male wearing the blue jeans, white shirt, and a blue jean jacket with the hood. And when they ran Mr. Barnes' license, they found out that his license had been suspended in April of 2004. He was then arrested and charged accordingly. This completes the facts of this case, Your Honor.
All right. Anything else?
I just have that he has approximately 34 arrest cycles with 12 misdemeanor convictions and 2 felony convictions, 2 felony convictions out of Bartow County. I have a 2015 conviction of terroristic threats, 12 CR 01439, and a 2015 conviction out of Bartow County of bail jumping. And these are the felony convictions, and that indictment number is 15 CR 00287.
All right. Thank you so much.
Thank you, Judge.
Good morning, Ms. Jackson. How are you?
Good morning, Judge. I'm great. How are you?
I am all right. Do you have different criminal history information or about the same 34, 35 cycles for?
About the same, Your Honor.
Okay. All right. Thank you.
Yes, sir.
Officer Evans, is Mr. Barnes on probation now?
Good morning, Your Honor. No, Mr. Barnes is not on probation.
Okay, thank you. Ms. Gordon.
Yes, sir.
Tell me about Homes of Light and what the plan is for Mr. Barnes going forward and anything else you want to share.
Yes, Judge. So Judge Ingram actually already signed a transport order to Homes of Light on October 30th.
I guess that ties my hands. Okay.
He is scheduled to be transported there. He will live there and receive support services there. And then he will also have a Grady ICM team. So he's already been accepted into all of those services after our social workers worked very hard on this. So I believe that he will have the support and the services that he needs in the community. I think that's all I have, Judge. For the record, he has been in custody a total of 600 days since his arrest date on March 2nd of 2023.
And 369 days for the other case. He got released, but the hitting people with a stick and cars, he did 369 days on that and then was released. So it's lots of time across the two cases.
It's lots of time.
Okay. If I make it a special condition of probation that Mr. Barnes stay at Homes of Light, is that an infinite he could stay there as long as he wants and complies? Or I don't mean to create a negative tripwire. If Homes of Light is 1 year until things are stabilized and then he's supposed to leave, then I don't want to say it's a condition of your probation, as long as you're on probation, that you stay at Homes of Light.
I am not certain of the answer to that question, Your Honor. So as of right now, I would ask that you not put that in the order.
Okay.
I will check with Ms. McNeil, who is the social worker who coordinated all of these services, and I'm
Okay.
happy to let the court know, the duration of the program or whether it is indefinite.
So I want to put some duration in, because if it just says you should go to Homes of Light, then the next day he could leave, you could leave, and that wouldn't be a violation of probation. And I'd like us to be able to ensure that he stays, assuming it's a safe place for him and all that. And I trust it is if your team found it. I think there ought to be some time that's required to be there where probation is a line of enforcement for that.
If the court is willing to hold off on the order, I can probably step out and call Ms. McNeil and get an answer for you.
Okay, looks like a colleague is doing that right now.
Wonderful.
Teamwork. All right, let me chat with Mr. Barnes a little bit and we'll sort this out.
Sure.
Good morning, Mr. Barnes.
Good morning.
Tell me, you take medication. What does the medication help you with?
I'm schizophrenic.
When you take the medication, does it make you sleepy or drowsy, or it just makes you calm?
Makes me more calm. Sometimes it's upbeat, like it speeds me up or something.
When do you take the medication?
In the morning and at night.
Did you get it last night?
Yeah,
Did you get it this morning?
yeah, I got some this morning.
Okay, so you feel like you've understood what we've been talking about?
Yeah.
Any questions about anything we talked about?
Well, the only thing I want to say is I remember doing everything but hitting somebody with a stick. I don't understand why they say that unless I just blacked out and done it.
It's possible you could, where you didn't even realize that you may have just been swinging it and it accidentally hit someone.
Yeah,
It doesn't sound like it caused a serious injury. I think it frightened people
yeah.
because they were worried about you and worried about themselves. But I appreciate you flagging that.
Okay.
No restitution for the damage to the Sentra, or it's nothing you're choosing to pursue given the situation we're in?
Yes, Your Honor, not at this time. No restitution at this time.
All right. Mr. Barnes, I find that there's
Sorry, Judge, I was just gonna give you a quick update. The Homes of Light program is 6 months to a year.
okay, great. Thank you. Mr. Barnes, I find there's a factual basis for your pleas, meaning if there was a trial, the state could prove that you were guilty. You're already accepting responsibility, but I find there's a factual basis. Also, that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. You've talked about it with Ms. Gordon and you think this is the right thing forward, the way to go forward for you. Is that right?
Yes, sir.
And a knowing plea just means you've understood what we've talked about. You've already told me that. So I'm going to accept your plea. I also find that you're competent to enter into this plea based on the evaluation that Dr. and the letter he provided to my colleague in March of this year, where this doctor who got to know you a little bit said that as long as you're taking your medication, you understand enough about what's going on that you can help your lawyer and you can make decisions on your own. So I'm going to accept your plea on that basis. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a little problem, you and probation can sort that out. You don't have to come back and see a judge. But if it's a big problem, you hit someone with a stick again, or you take someone's green F-150, then you're probably going to have to come back into court. Okay?
Okay.
All right. I'm going to sentence you in 23 SC 189154 to 5 years to serve 1 year. You'll get credit for the time you already served in that case, which was 369 days. That's more than a year. So you are releasable now on that case. And it will be a special condition of your probation that you, is ICM the same as ACT? Have they renamed it or it's different?
They're two separate programs. But
How are they different?
So ICM is Intensive Case Management, ACT is.
None of the names are different, but if I'm in ICM, what do I get or not get that someone in ACT gets?
I have to look back
I
at my
don't know.
email.
All the hard
Your Honor.
questions.
Still new on the
Okay.
competency stuff, Judge,
Me
I'm
too.
still learning about all
I'll
these
forward you an
programs.
email. I do have that information, but I just can't
Okay.
call it.
It's not changing my mind at all. I was just curious if they rebranded or if
It is.
ICM is a higher level of care or a lesser level of care. It's not changing anything I'm doing, just curiosity. We'll press on.
Thanks.
You will need, Mr. Barnes, to continue to participate in the Grady Intensive Case Management business. And for at least 6 months, you need to stay at Homes of Light. You may be able to stay longer and you may want to stay longer. But if you're there for 1 month and you decide, I'm good, I'm gonna go be free, that would be a violation of your probation. You need to stay with the good folks at Homes of Light, okay?
All right.
All right. And you'll need to continue to take any medication that any doctor prescribes you.
Yes, sir.
So if it's making you feel a strange way, have a conversation with the doctor. Don't just stop taking the medication, and maybe they could give you a lower dosage or medicine that doesn't have the same side effects. Ms. Gordon, you said there's already a transport order, but that's not till October 30. So a time served sentence isn't a good one now because there'd be a 8-day window where Mr. Barnes would be out.
Yeah.
Okay.
Is that
All right.
reporting probation? Reporting probation?
Oh, he's asking if it's reporting probation, Judge.
So I'm going to ask that probation assign a special probation officer who works with folks who have some of the challenges you have. I don't know what reporting will mean. It may be because you're at Homes of Light, they'll come to you, or you can do it on the phone. But certainly at the beginning, you and your probation officer are going to be talking pretty regularly because I want to make sure you're staying in the program and doing okay.
Yeah.
Now, a little ways down the road, if things are going well, maybe it's non-reporting.
Okay.
Okay.
Well, the only reason why I asked is it's probably hard for me to get to it.
Well, they have ways of working around that, but that's a great point. If we do not want you taking another Ford F-150 to get down to the probation office, okay?
Yeah.
You don't have a driver's license, so you shouldn't be driving. You take a bus or you jog down there, okay?
Okay.
You got your other case, 24 SCs. Oh, I didn't do the second count. So the first count was that 5 to serve 1, balance probated, and count 2 is 12 months to serve. But you've already done the 12 months. That takes care of the 23 SC. On 24 SC 000296, I'm sentencing you to 5 years to serve 2 years. And those 2 years will be reduced to time served once you get to Homes of Light. You're going to be transported there next Wednesday, a week from tomorrow. Okay, so you got to be where you are for about 1 more week. And then someone's going to pick you up, take you to Homes of Light. The balance of that sentence will be on probation. Count 2 is 12 months to serve. That'll run concurrently. And both cases run concurrently with each other. And in this second case, the SC case where you took the F-150, again, it's a special condition of your probation that you stay involved with Grady Intensive Case Management and that you stay for at least 6 months at Homes of Light and that you continue to take your medication as prescribed. Ms. Sellers, anything else in connection with Mr. Barnes?
Nothing further from the state, Your Honor.
Ms. Gordon, that's 1 more year of probation than you all had negotiated. But I think a little more supervision is better. And if Mr. Barnes is doing well, we can always restructure things. Anything else on behalf of your client?
No, Your Honor.
Officer Evans, what do we need to do about reporting?
Your Honor, at this time, I sent an email to Attorney Gordon to request the information of where the defendant will be. However, I would like to get a contact person and phone number for the defendant and provide him reporting instructions of 24 hours of release to probation if in fact that something happens at which he's not transported directly to that program. And he's
Okay.
released,
Got it.
for whichever reason.
But if he does go straight to Homes of Light, he does not then need to report to probation. Probation will figure out a way to connect with him at Homes of Light.
Yes, Your Honor.
Okay, got it.
And Judge, I'm happy, I'll obviously respond to Ms. Evans' email. Also, though, I don't know if she has access to Odyssey, the transport order that Judge Ingram signed and filed has all of the Homes of Light information with the address, a contact person, and a contact number.
Great.
And Your Honor, I just sent you information on Grady Act team as well as intensive case management.
All right, excellent. Officer Evans, are you able to get into Odyssey?
Not at this time, Your Honor. So if I could have that mailed to me, I appreciate it.
I'll send it.
Yep, we'll make it happen. Okay.
Thank you, Your Honor.
You bet. Anything else? Mr. Did you have it?
Yeah, I sent her right now. What's her first name? Officer Edwards.
Lindsay, Lindsey.
Okay, I'm sending it to her then.
Great. Ms. Green's sending it to you. All right.
Thank
Mr.
you.
Barnes, you have any questions about anything?
No, sir.
All right, stay in the program, okay?
Okay.
All right. Thank you, everyone.
Thank you, Judge.
Can you hand to?
Oh, I do have it. Okay.
All right, Investigator Gonzalez. So you're just trying, you guys figured out through the flock cameras where this forerunner went, whatever it was.
Yes.
Hey, what's the same phone that hits all these cell towers? Yes, Your Honor. It was abandoned ironically in the courthouse parking lot. That's kind of a heck you move.
Yeah, so that's where the incident occurred up in Buckhead.
Yeah.
And then shortly after the burglary happened, and then he was traveling up and down.
Yeah.
Different highway.
Okay, good job. So this is just the evidence, like, what's the one phone that's in there?
Yes, Your Honor.
Great, you swear from the contents of your affidavit are true and correct to the best of your belief and knowledge.
Yes, Your Honor.
Hope the technology works. So I've signed where I need to, so the warrant is good to go. You can sign there if you want. But you need to,
Yes.
it broke up, but sign there and I guess. You're all set.
Thank you, Honor. You have a good one.
Hey, Judge, how are you?
I'm well, how are you?
I've seen you in a while. You doing okay?
Yeah, I am doing all right. You?
Doing good.
Good.
Doing good, doing good.
All right, let's check in on the calendar because a little time has passed. Ms. Wood is here, Mr. Fortis is here. So let's see if we have any updates on our final plea. Ms. Wood, any update on Mr. Suttles, or does that remain a work in progress?
Judge, we're gonna work on it a little bit more. I wanna resolve it all together and.
That would be great. That's why we got this new case. He's got 3 cases now.
Yes, and so Miss Nix and I have been working on the newest case, the
Okay.
arraignment, position 3.
Yep.
So it may not resolve today. She had to do a little bit more digging to locate someone.
Okay.
But I'm gonna give it a little bit more time. And I do have an announcement on position 10.
All right, well, I'm working my way down there. How about Michael Reynolds? Do you need to chat with him? Okay. Charles Ellison is here. This you, Mr. Fortis?
It is, Your Honor. Need a few minutes with Miss Nix. Subject to that, I guess we'll be ready to go on the 14th.
Is that where, I forgot to ask Ms. Nelson if these cases, are these all on the November trial calendar?
Believe so, yes.
Okay, great. Ready to go is what you need to be. How about Ms. Honholt? She may not be up yet.
I think she's possibly not even here, Judge.
Oh, she escaped?
However,
Oh, I remember this woman.
Cherokee County.
Yeah.
this is not going to resolve today unless the state's dismissing and giving an apology letter. So,
I don't see the letter.
so Miss Nelson is kindly working to arrange a Zoom session.
Yes, reset for next week via Zoom, she hopes.
Perfect.
Okay, Zoom might be the best way to do this.
Yes.
Yeah, okay. All right, let me write that. Reset next. Hope we don't all get sued. Divinity Rivera, any update from diversion?
No, sir.
Okay, we're gonna ask one more time, Ms. Rivera, so sit tight, then we'll get you out of here. Mr. Williams will hold on, Mr. Gomez will hold on, Duranta Jones, position 10.
Judge,
Is he here? He didn't show, that was a bigger issue.
Yes, I don't have any working numbers for him at this time.
Okay. Bench warrant for Mr. Jones. All right. then you can talk with Ms. Nix. I got another plea I can do from the competency docket. And then we can start doing bond hearings. I read that it isn't Mr. Rao for all three. One of them, Ms. Jones Connor was gonna do one, but maybe you're doing it for her.
I'm just gonna do all.
You're gonna do all three? Okay,
I'm here.
all right, great. Ms. Beck, is there there may be a bunch of folks here for one of your cases. Is there an order in which are you doing all three also? It's basically the Rao and Beck show?
Yes, Your Honor. I do have an announcement on one of the petitions. Her murder charge was dismissed, so she was already granted a bond and everything else. I don't believe she's eligible for today.
Who's that?
Israel.
Oh, that's a she also?
Yes.
Okay, that's now just, so let's look that up.
Yes, Your Honor.
She was given
Had a-
$100,000 bond on
Yes.
October 9th.
So she has a bond and it must have been because the murder went away, another judge could.
Correct, yes, Your Honor.
Okay, so if she's here, I can talk with her real briefly just to let her know, but we won't work through that. Okay.
But I will be handling the other two. I just need a moment to speak with them in the back, but I was told that they're not up yet.
Thank you. 0068. So now it's just kind of false statements and things like that. I guess it's sort of after the fact.
Yes, Your Honor.
Okay, got it. Okay. Deputy Gordon, do you know if Ms. Yisrael was brought over? Okay, if she was, when we bring them all up, I can chat with her then. So just talk with Mr. Rao about which of the two you want to do first. And why don't we do Mr. McBride now?
Ms. Ellison, step out, Mr. Barnes should be right.
Okay.
Judge, I have one question about Mr. Barnes. Is his attorney fees waived?
Sure, we don't normally, they waive the attorneys. I forgot to say that supervision fees are waived. We should definitely waive the probation supervision fees. Is that something that's typical in the competency docket to waive the attorney's fees too?
It's part of the provision. I just have to ask.
That's fine. We're gonna do Mr. McBride now. Get you on your way.
Oh, sure.
Yeah, just one case?
Yes.
Nice to meet you. Okay, I was just, I just spoke about for a special procedure. The one with. Oh, yeah, Josh, thank you. Did you okay?
Yeah.
Any questions for me before we get started? Oh, sorry. This is the accusation charging you with just one count of civil battery against a detention officer, a misdemeanor. Not to be guilty today, the sign line right there above where I just.
Thank you.
Walk in to Pat. So this is. This social worker, who said that you agreed that you were gonna add once you get released.
Oh, sure.
Okay, so this is new today. Thank you. Multiple calendars. Did she give you information on where to come today?
Hey, just, she said when
Your bond on.
I get released, she said they said like her name.
Yeah.
Okay, that's fine. So thank you at the jail.
Yeah.
Okay.
Both of us been here.
Yeah.
Oh, you got trial next week, so.
No,
I do.
Because if you don't, then you're right there with me.
No, we're in the same boat. So my trial, I've prepped before.
Like an address, phone number.
Yes. Sure. /New Kirk.
We good?
Already on.
All right, let's go on the record in, oh, I need the indictment number. I have a CP number here.
It is 24 SC 005275.
All right. So that's the case we're going on the record for. 24 SC 005275, State versus Mr. McBride. Hello, Mr. McBride.
Morning.
How are you doing today?
I'm okay.
Good. I'm Judge McBurney. We've not met before, but I'm going to handle your plea today. Ms. Gordon told me you're ready to resolve this case. Is that correct?
Yes.
Okay. Ms. Sellers, who's the prosecutor in the case, is going to ask you some questions in just a moment. You should answer them as best you can. If at any point someone says something that doesn't make sense to you, or you can't hear it, or whatever's going on, let Ms. Gordon or me know that, will you? Yes?
Okay.
Good. You got to speak up because you're wearing a mask, and that's fine. You're welcome to keep the mask on. But Ms. Rivers, who's sitting right in front of me, needs to be able to hear you. So you got to project a little bit. So a little bit of outside voice when you are answering the questions. And even though some of the questions may be yes or no, I need you to say some words. You can nod your head or shake your head, but also answer out loud because Ms. Rivers only writes down what you say. Okay?
Okay.
Great. When you're ready, Ms. Sellers.
Thank you, Your Honor. Do you swear or affirm that the statements that you will provide to the court today will be the truth, the whole truth, and nothing but the truth?
I don't really understand it.
She's asking if when you answer the questions.
Okay. Yeah.
Are you good with that? Just you're gonna make sure that whatever you say is truthful?
Yes.
Yes, great. Okay.
Please state your true and correct name.
Glenn McBride.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Medicine.
Okay. What is that medication?
Abilify.
And does that medication affect your ability to understand the proceedings today?
No, man, I don't believe so.
And are you able to understand medical? How old are you?
39.
And how far have you gone in school?
Ninth grade. Ninth grade. Ninth grade.
Ninth grade. So you have completed the ninth grade.
Yes, ma'am.
Do you understand that you are being charged with the following offense? In 24 SC 005275, and that offense is simple battery against a detention officer. You understand that you have the right to plead either guilty or not guilty to this charge.
Yes.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
And I'm holding up an accusation. And this is 24 SC 005275. Is this your signature?
Yes.
You have this accusation to the court.
Thank you.
Have you had enough time to speak with your attorney, Ms. Gordon, about all of the facts and circumstances known to you regarding the charge in this accusation, including any potential defenses?
Yes, ma'am.
And do you need any more time to discuss this case with your attorney?
No.
And are you satisfied with your attorney services today?
Yes, ma'am.
Counsel, do you waive formal reading of the accusation?
Yes.
Do you waive any and all defects in the accusation?
Yes.
And has your attorney advised you of the minimum and maximum sentence for the charge listed in accusation number 24 SC 005275? And you understand?
She's asking if you understand what the minimum and maximum.
Okay. Yes, ma'am. Yes, ma'am.
So you understand that the minimum is 1 day and the maximum is 12 months on the charge listed in this accusation.
Yes, ma'am.
Do you understand that this is a negotiated plea, which means that the state recommends a time served sentence, 12 months to serve, reduced to the time that you have already served. But the court does not have to follow that recommendation and can sentence you to up to 12 months on this charge. Do you understand that?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand that there may be Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
You understand that by pleading guilty, you are giving up the following rights, and I'll go through a list of those rights. Giving up the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of this charge after a trial. You understand these rights you're giving up today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
And it is your decision to waive these rights and enter a guilty plea because you are in fact guilty.
No, ma'am.
You don't want to enter a guilty. What she's asking is it your decision today to enter a guilty plea in this case?
Is this an Alfred plea?
Just give us one moment.
Yes, perfect. Fuck me, not guilty. What's that?
If you're not guilty, that means.
How long would it take?
I'm not sure how long that would take.
Yeah, I'm pleading guilty. Yeah. Yes, ma'am.
So I'm gonna pop in here just for a minute, Mr. McBride. So you're saying that you are admitting, this case involves, it's a long time ago, but you apparently put your hands on someone at the jail that you weren't supposed to. And you're admitting, yep, I did that. Sorry it happened.
Yes, sir.
Okay, thank you.
Thank you, Judge. How do you plead to the charge of simple battery against a detention officer in accusation number 24 SC 005275?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
And do you understand that you may have only a limited right to appeal this guilty plea conviction?
Can you repeat that?
You understand that you may have only a limited appeal this guilty plea conviction?
Yes, ma'am.
And you understand that you have 12 months from today for this misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
At this time, Your Honor, the state will go on the record with the facts in this case. That on May 29th, 2023 at approximately 7:48 a.m. at 901 Rice Street in Atlanta in Fulton County. Sergeant Chambers, detention officer Pemi, P-E-M-I, advised that she was assigned to 4 South as the floor detention officer on the 7 p.m. to 7 a.m. team at the Fulton County Jail. She stated at approximately 7:50 a.m. she was getting the trustee out for the next shift when inmate Glenn McBride, housed on the boat in zone 400, tried to run out on her. The detention officer Pemi stated she tried to inquire why he wanted to leave the floor, which was his reasoning. He stated that he had just gotten stabbed in the zone. She stated she asked inmate McBride to show her, but he couldn't show her any signs of him being stabbed. Officer Pemi then advised while she was having a conversation with inmate McBride, he swung on her, slapped her in the face, and knocked her glasses off of her face. The detention officer then removed her Fulton County issued taser and deployed one prong towards McBride, but that was ineffective. She stated that with the help of the inmates in the zone, she was able to subdue inmate McBride and was able to place him in handcuffs. And then advised that help arrived and the inmate was escorted to medical to be evaluated. And that completes the facts of this case, Your Honor.
Right. And your recommendation is 12 months to serve, but he's done over 500 days, so he's done just 12 months.
Yes, Your Honor.
Okay, thank you.
Thank you, Judge.
Ms. Gordon, what's gonna happen to Mr. McBride when he gets out? He's getting out. 12 months is 12 months.
Yes, he is going to live with his mother and his brother at an address that I can provide for the court if you need it in Atlanta. And he is going to, he's spoken also with, I think his social worker is also mistaken. And he's planning to walk in and partake of the services that Pat has to offer once he is released.
Okay, I hope that happens. Officer Evans, is Mr. McBride on any form of supervision that you're aware of right now?
No, Your Honor, not at this time.
Thank you. All right. Mr. McBride, do you have any questions for me about anything we talked about?
No, sir.
Are you okay going home to live with your mom?
Yes, sir.
Is that a safe place for you?
Yes, sir.
Will you be able, you said you're taking Abilify?
Abilify, yes, sir.
Will you continue to take that when you're staying with your mom?
Yes, sir.
How do you get it?
I have to go to the hospital on 10th Street and receive a dosage there.
Okay, so you have a source, a medical source for Abilify or something like that when you're not in jail.
Yes, sir.
Okay, because you've been in jail for a long time. That you'll still be able to get your medication there?
I believe it's a possibility, yes, sir.
Okay. Is your mom usually pretty helpful in making sure you take your medication?
Yes, sir.
And who else lives at home with you and your mom?
My brother.
Your brother?
Yes, sir.
Is he older or younger?
Older.
Older? Does he work?
I believe so.
Okay. All right. Well, Mr. McBride, I find there's a factual basis for your plea. Oops, give me 1 second. That in May of last year, you got into a scuffle with this detention officer in a way you shouldn't have. I also find that your plea is what we call knowing and voluntary. Voluntary means no one's forcing you to do this, but you've decided after talking with Ms. Gordon and maybe some other people that you want to admit responsibility and be done with this case. Is that a fair statement?
Yes, sir.
Okay. And a knowing plea just means you've understood what we talked about. And when you didn't, and I watched the and she whispers something to you and say, oh, okay, I get it now. Do you feel like with the assistance of Ms. Gordon's explanations, you've understood what we talked about?
Yes, sir.
Okay, well, I find that you did too. I also find, based on the letter dated June 26th of 2024, from Dr. Clayton. That's a doctor who met with you at the jail to talk to you a little bit about the medication you take and your history of medication and whatnot. She has the opinion that you are able to help your lawyer understand these questions and meaningfully interact with us in court. And so in relying on that letter and incorporating it here in this record, I will accept your plea and I will follow the recommendation, which is to sentence you to 12 months to serve, but you've already done 18, 19 months. So you're going to be released. If not today, then tomorrow. You're going to need to go to your mom's, settle in there, and then make sure you keep getting that medication because that's what's going to keep you in a stable space. Okay.
Okay.
And I hope you go by Pad. Pad's a great place. You can walk on in and say, I'd like some help with this or that. And it's all voluntary. You can say no thank you to them, but they will try to connect you with resources, okay?
Okay.
Have you ever worked with Pad before?
No, sir.
Okay, well, I hope that's something that you explore. Ms. Sellers, anything else in Mr. McBride's case?
Nothing further from the state, Your Honor.
Ms. Gordon, anything else?
No, Your Honor.
All right, I'm gonna waive attorney's fees in this case and we'll close it out. Thank you.
Okay.
Thank you, Judge.
If you would give this to Ms. Green, you are all set. I appreciate your time.
Thank you. Thank you.
All right, why don't we do one of the bond hearings? Do you want to do Ms. Fields or Ms. Rasheed? Ms. Beck stepped out though, maybe we can't do that.
I'm good with either one.
You're
Yeah, that's
cool.
all right.
Okay.
We can do them consecutively.
Yes, ma'am, thank you.
And if we can do the bond hearings consecutively,
We'll see what the flow is. I like mixing it up a little. Oh, they're not here, so we can't do that yet.
You're down.
Okay, I mean, they're not up, so let's see if Ms. Wood, is there anything we can do with someone who's up? And then we've got to take a quick break so Deputy Gordon can bring up Ms. Fields, Ms. Rasheed, and there may be someone on that.
Okay, if I could just have a few minutes to get back, I should have an announcement.
Okay. Why don't I talk with him real quickly and then I'll take a break. She can talk with Reynolds, you can bring the ladies up and we'll truck on, okay? Can you bring Mr. Gomez to the door, please? Thanks.
Oh, you would, okay.
You should be. He's like, he's like the person. Oh.
Hey, Mr. Gomez, how you doing? So I just want to give you an update. Your lawyer is in trial right now. She's got a murder trial. She's doing a few floors down. Because we were going to talk about your case a little bit today. I didn't know she was in trial, so we can't do that. She's trying to connect you with a doctor just to talk a little bit about how you're doing. So she's going to keep working on that. But once she's done with that murder trial, we can have a conversation about your situation, okay? No, her murder trial is this week. So when she's done with the murder trial at the end of this week, we'll figure out another day when you and I and the prosecutor, young lady in the white jacket there, and your lawyer, Ms. Cabrera, can talk about your case. Yeah, she wanted to have a doctor talk to you about how you're doing, if making sure you're getting the care you need while you're in custody, that kind of stuff. Yep, this is for evaluation to make sure if there's medication you should be taking to keep you in a safe space. Exactly. Good, okay, and I'm gonna see what we need to do to help her make that happen, because that should have happened already. I'm kind of surprised it hadn't happened yet. That's not on you, it's on her, so I'm gonna nudge her a little bit, okay?
So I got a new time to be fine. I have a new down policy evaluation started.
Yep.
All right.
Okay. Good to see you. So we're gonna take a quick break. We're gonna bring a couple inmates up, female inmates. And Ms. Wood's gonna talk to a client and we'll keep moving on. Oh, let's do last time. I don't want to keep Ms. Rivera here. Still nothing from diversion? All right, so Ms. Rivera, your case is going to move to a trial calendar. That doesn't mean you're going to have a trial. I just want to keep your case moving along. Ms. Cabrera will finish her own trial later this week, and she'll be bugging the prosecutor about making sure you can get into diversion. If for some reason you can't, you're not eligible for it, Ms. Cabrera will let you know that and we'll figure something else out, okay? So you don't need to stick around anymore. Thank you. You bet.
Ron, can I give you an updated announcement?
In just a second.
Okay, thank you.
All right, yes, announcement on Mr. Ellison.
We had negotiated.
Great.
If we can do it today, that'd be great.
We will do it today. If you guys are ready, when we're done with the break, we'll do that. Then we'll do one of these bond hearings.
Right.
All right.
Thank you, Charles.
Great. We're on a quick break while they're moving some inmates up and I'll get out of here. You'll let them, talk with their folks. Okay.
As soon as you get out, I'll take them.
I'm leaving.
How you doing?
Doing well. How are you?
Yeah, I'm all right. I'm still doing fine, sir.
Good.
I've been in the courtroom at least twice.
You have. I remember you. I'm glad you're here. I mean, this isn't my courtroom, but it's mine today. Yeah. Yeah. All right. So I guess if you'll have Deputy Gordon text me when you got everyone back up, and then we'll take a plea and do some of these bond hearings.
Yes, sir.
Thanks.
Yes, you did.
Thank you.
Oh.
It's just, we want to make it just
And he got where
Isn't that crazy? Yes. So for lettuce.
10:30. I don't know if that's gonna happen, so. I can, yeah, I mean, I can go here, but I know passport stuff, it might be lost. So I think that for
I'll see you, let's see if I can. I will. I say, is he paying you like, yeah?
Oh, no. That's the kind of stuff.
I just put it, well, it's all my comments. But, yeah, I was wondering. Yeah. What is that name? Now that I'm talking about it, I think it might have been a partner. Yeah, like for like, haircut. I don't know, this felt as if I'm for radar. I don't know why it is for that. Okay, thank you. Oh, God. Not yet. Okay. Are you still there?
Yeah, but, yeah, I'm on hold.
Okay, so whenever Jordan touched it,
Okay, cool.
I thought that would be before you walked in.
You didn't think that was so cool. Just a hurricane outside.
Everyone talks out like this.
Is it time? Is it time?
She's retired. That's fun stuff. To see you in person. Right, it's not all sounding good. How you doing? Unclear. No, that's just really bad.
It is hard. Everyone's to see Robert.
Fancy seeing you here.
What? You want me to go through did you say to
Died.
Oh,
You
the
good?
email?
Yes.
An email. How do you look like you just need a commercial?
Not really good.
Like a commercial. How's the ankle monitor cord? How'd it go? I saw, I was going through security with True. So I saw there's somebody, I saw Tree, I walked through security with Tree, and she was like, yeah, my client's in prison for 10 years. I'm like, who's monitoring the monitor?
But is it still, is it in DOC?
Yeah, I don't even know where the thing is.
The margins like.
You know that. I'm gonna bring him up.
No, he's up, but Gordon, we're getting him some shuffle, I guess. She has all the people behind us.
Oh.
The shuffle. Gotcha.
Right.
Okay. Sorry, Mary, must be such a too quick for lighting here. How's that work?
That was quite a
That's the same one.
So it's Kate?
There's not
Me,
several
no,
other
why?
areas.
No,
It's pretty big.
You said it was, oh, you always said it was Kate.
I got you. No, she says it like she's. We could twice a year. Yeah. Yeah, I feel like I've heard it. Yeah, I've heard it. There's a lot of stuff, like there's a lot of just design down there. Really? But it's bigger than like this one. Oh, because that's in there. God. Gotcha. Yeah, this is where I've been pretty every day, dude.
She got a lot of. She's bad at all. Never seen her so. You have never seen her so.
She has one of those like raised desks.
Oh, really? She sat down.
Uh-oh. We'll let him do that. That's really nice. Hair. It was a cool. Oh.
Did you go to that?
Yes.
Who wants that?
Thank you.
Skeleton and a ghost. So now.
So which one do you want to be? Yeah.
No, I'm just. So he's been, I'm gonna do a skeleton, I'm gonna do a ghost. He gets crossed on. And I tried a lot of. Try to put it on him, though. Now he's scared. Yeah, he's scared.
He put it on.
Everything, he was Halloween, on Halloween on the iPad, everything. Now, he goes try to decorate the house and he's scared. I was wrong. You want this, this is what you asked for. Yeah, we have the. Yeah, that nail, goes in the dark, we're scared of that. Yeah, I'm like, you were just asking for to be this and be that, and now you scared. I might dress up. I've been thinking about it. Dress up. Dress up a little.
Batman and Robin or something.
He like playing with the actual ghost costume. He's scared of the skeleton because it has a mask.
Yeah.
So he don't want to put on a mask. All cell phones should be put away. Adjustment. You actually got this. That's why I sent him out. I'm like, he's not gonna go, so I sent him out. Who? You doing a photo stuff? I'm doing it. Yeah.
No, I mean, I'm also trying stuff about her this week and
Yesterday. And see that
That was great. Remember it?
Was it like 3 years ago?
Yeah, it was like 2 years ago. Crazy. He ran out. It's on video.
Remember that? I hadn't seen the video. In that case, it was Kingdom Name. Which court was it in?
I'm worried that I saw this picture.
I would finish the one with the guy.
Oh. When did this happen?
What kind of one? May I see it?
All right, are we ready, Ms. Nix, on the Ellison plea?
Yes, sir.
Is Ms. Wood still back talking with people? That's all, that's good. We don't need, we got who we need for Ellison. Working? Ready?
It's very loud.
This, how it works in this courtroom. I don't know how they get a higher volume than ours. Katrina. Are you good to go? Mr. Ellison, are you ready?
Yes, sir.
Okay, we're gonna go on the record. Your case is 23 SC 190-119. You're here in court with your lawyer, Mr. Fortis. Ms. Nix is the prosecutor. She's gonna put you under oath, ask you a bunch of questions, and we'll see where we go.
Yes, sir.
If at any point you've got a question, let your lawyer or me know, okay? Ms. Nix?
Thank you, Judge. Mr. Ellison, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
Charles Howard Ellison. Charles Ellison.
You can move the microphone so that you don't have to lean so much. There you go. Ooh. Maybe we shouldn't move it.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
27.
How far have you gone in school?
Year college.
Is English your native or dominant language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses: fleeing and attempting to elude, speeding, and reckless driving?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against the trial?
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney? Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
Do you need more time to discuss the case with your lawyer, Mr. Fortis?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Mr. Fortis, do you waive a formal reading of the indictment for purposes of the plea?
We do.
And do you waive any and all defects in the indictment for purposes of the plea?
We do as well.
Mr. Ellison, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? So count one, fleeing and attempting to elude, state will null pros upon a plea of guilty to counts 2 and 3. Counts 2 and 3, state recommends 12 months probated to run consecutive with each other for a total of 24 months. Special conditions are 100 hours of community service and that you complete a defensive driving class.
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you're expecting today, you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Right.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of speeding and reckless driving in indictment number 23 SC 190119?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction? Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas petition?
Yes.
Do you understand that since these are misdemeanors, you have only 12 months from today to do so?
Yes.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about September 27th of 2022, the defendant was driving on I-285 southbound, which is in Fulton County, in a at speeds in excess of the posted speed limit. The defendant was going approximately 140 miles an hour in a 65. The defendant was driving recklessly by changing lanes quickly and by speeding excessively. And that occurred in Fulton County. Yes.
What's the reason other than negotiating for dropping the felony cap?
Judge, the defendant was going so fast that the officer took a long time to.
I think that's that microphone up there.
Not at all.
Yeah, but you can't mute that because that shuts everything down. So turn it back on and.
I think it was already off.
It was off when I came up here.
Oh, now it's on?
So he turned it on.
I turned it on when I came up.
Oh, okay.
We did all the other things while it was off.
Really? So turn it off and let me see, please, turn it
Sorry.
off.
It's
Ms.
off.
Ms. Nelson, are you able to hear us? Don't mess with it. Is it on or off?
It goes off, then goes back on. So now it's on. Like it won't stay off and then it comes back green being on.
Okay. What color is it now?
Green.
Okay, let's just leave it and we'll see what happens. He was going so fast, it took the trooper.
A while to catch up. Once the trooper did catch up, the defendant did pull over. And Mr. Fortis tells me that the defendant did not realize the officer was trying to pull him over, which I agree is a fair interpretation of the video.
Okay.
And so the state's made this offer because the defendant was going a ridiculous speed and driving very recklessly. But we could understand that because he was going so fast, he may have not realized that the officer was trying to pull him over.
Right, you're going warp speed, you don't see the flashing.
Yes, sir.
Okay, all right. Ms. Jackson, do you have any criminal history information for Mr. Ellison?
Yes, Your Honor. He has 5 cycles. The last arrest was January the 7th, 2017 at a Grovetown, Georgia Police Department for DUI. That charge looked like it may have been changed or amended to a non-fingerprintable offense, Your Honor, in 2017 as a misdemeanor conviction. Nothing in addition.
Thank you. Mr. Fortis.
Yes, Your Honor. As stated earlier, Mr. Ellison is 27 years of age. He's educated, offering no excuses as to why someone's going that rate of speed. But to put this into some sort of context, he was late for work. And I guess he was driving at the time for Amazon. And if you are a minute or two late, then you're not able to drive your shift. So it was a complete, utter lapse of judgment because not only did he put himself at risk, but obviously the other drivers at risk on the road. And he wasn't thinking about that. But just to give you a little bit of history on who he is, number one, his mother is in court today. Both his mother and his father are both military. They're both in the medical field. His mom, who's here today, works out of Augusta for veterans who have cancer. So this was a complete shock to her. She was disappointed, to say the least, and she has been actively involved in this case along, with Mr. Ellison. Currently, he is working to become an HVAC person. He's going through the classes. He's also doing an apprenticeship. He's also engaged to be married. He doesn't have any children as of yet, but he's very remorseful about this. He's disappointed in what he was doing. And when I asked him, what were you thinking? The only thing that he could say is, I don't know what I was thinking. It was just a really, really poor judgment. I'm better than that. And I do believe that he is, and I believe that he has the background and the family support for that. And to just add on to what Ms. Nix was saying, he never saw the officer behind him, but when he was getting over and was slowed down and looked, he saw the officer, pulled immediately over, put his hands out, it's all on video, put his hands out the window. So he was very compliant, Like that was not an issue. There were no warrants, there was no suspended license, there was no contraband. Made no sense, but nonetheless, here we are, lesson learned, message delivered, and we would ask the court to accept the recommendation.
All right. Mr. Ellison, anything you want to add?
No, sir.
So you are working now in this apprenticeship, or you're hoping to get the apprenticeship?
No, so the school I attend is Fortis College. And so it's a half like internship and half schooling. So all three of my professors have their own HVACR company. And so we do jobs with them while we're learning.
Do you work for free because you're a student, or you get paid a little bit?
No, we work for free because we're students.
Okay, a good deal for the professors.
Yeah, right.
Okay, what were you driving back in September of 22?
An Infinity, Infinity Q70.
And you were on your way to your job at Amazon?
Yes, sir.
All right, you're engaged now?
Yes, sir.
Okay, well, Mr. Ellison, I find there's a factual, and you spent 8 or 9 days in jail before you bonded out? You were in for a little while.
Yeah, yes, sir. Those are closer to like 15.
Okay,
Yeah.
and was that because the bond was too high, or you didn't have a bond at first? Or your parents were just letting you maybe marinate a bit?
It was a tricky situation from what I.
What does that mean?
We actually.
No, this one, but I know he's asking,
Oh.
I don't know the understanding answer.
I don't know. That's what's supposed to.
What was the tricky situation? He's asking why you didn't bond out of jail, why you spent 15 days in.
Oh, because we had to wait for Plea.
When you were in jail, how about, because you were on a fair trip here? When you originally got arrested,
Oh,
when you originally got arrested, did they make your bond right away or they didn't?
no, they didn't. I don't believe so. I don't really remember.
He doesn't really remember, but it's something to the effect of, I don't know if they made his
Yeah.
bond right away.
Okay, all right. What was the tricky part?
I thought we were talking about just recently.
There was an FTA in.
Right, there was
Yeah,
a.
it was an FTA.
We worked through that.
Yeah, that's why I said tricky situation. I'm
All
sorry.
right, okay. All right, I'm gonna follow the negotiated resolution for the most part. So count 1 is dismissed, the felony, that's the big change. Count 2 will be 12 months on probation. Count 3 will be 12 months on probation. They'll run consecutive to each other, so it's 24 months probation. You do need to complete a defensive driving course and do 100 hours of community service. I'm also assessing a $500 fine. That's the one tweak to it. So there's a monetary penalty as well, just to drive home the gravity of the situation. Not that you maybe tried to elude the officer, doesn't sound like that's the case. It's just how fast you were going.
Yes, sir.
Could have ended poorly for you and anyone else who was on 285, trying to just go about their business at more or less the normal speed. And that's it. Let me see if there's anything else. So I do find there's a factual basis for your plea. Your plea is knowing and voluntary. Ms. Nix, can someone in my office sign the indictment on your behalf?
Yes, sir.
Can we sign for you, Mr. Fortis?
Yes, Your Honor.
Mr. Ellison, is it okay if we electronically sign your name indicating your plea to counts 2 and 3 and the dismissal of count 1?
Yes, sir.
You're gonna get some information. It may come from Mr. Fortis, it may come directly from misdemeanor probation, giving you reporting instructions. Where do you live? What city?
Midtown.
Okay. They may make you report in person. It's about a block from here.
Okay.
Literally down the street from here. They may say, hey, let's just talk on the phone. Given the nature of your offense, they're not gonna need you to be reporting once a week and taking a drug test or anything like that.
Yes, sir.
But you gotta follow whatever their instructions are.
Understood.
Okay, and the community service, that's a lot of hours. If you are passive about it, they're gonna find you a way to pick up trash on the side of the road. It doesn't have to be that way. If there is something that you're passionate about, give them your time to talk with probation about that. And as long as you can document it, so it's not just you signing it or your mom saying, hey, he mowed the lawn 10 times, but the organization, you can give your time that way.
Understood.
And probation can help you come up with some ideas other than picking up trash on the side of the road. Not that that's not important. Any questions about anything?
No, sir.
All right, good luck.
Thank you so much.
And Judge, no,
Mr. Fortis,
thank you, Judge, no relation to the college.
thought that was your side business.
Which one was the business? See you, Joe. Good to see you.
Bye. All right, let's do one of those bond hearings. Ms. Beck?
Thank you, Your Honor. Could we start with Gabrielle Rasheed?
Sure. I'm fine. We have to draft something. We've done something like this before, not long ago.
You can, whatever, as long as she speaks clearly into the
She's
mic.
gonna swear up and reach and he's being a judge signing. I don't mind doing
How
it.
are you?
So
Thank
this is
you.
not uncommon, meaning this passport office does. It's uncommon.
Right.
Mom says,
So that's your.
gotta go. So.
I got you.
I don't know that I have a go by, but I don't have anything particularly profound.
I'll have something, I just.
Oh, okay. They are more fluent in that.
Oh, sorry.
Yeah, oh, yes, it does. What's the status? Okay. It's easy in Florida. Let's just do it. Thank you. Give me 1 second. All right. You're Ms. Rasheed? All right. We'll go on the record in your case. It's 24 PI 006788. Ms. Rasheed, you've been charged with murder, and all we're going to talk about today is bond. You're entitled to a bond hearing. Yours was delayed a bit because the magistrate who handled your first appearance isn't authorized to consider bond for murder, rape, a few other real serious allegations. So Ms. Beck is going to share with me why you should get a bond, what that bond should look like in terms of dollar amount and any kind of conditions. Mr. Rao, who is a prosecutor from the district attorney's office, is going to give me the state's perspective, maybe opposing bond or saying if there is one, it should be a higher amount or who knows what. In that exchange with your lawyer and the prosecutor, I may ask a little bit about the allegations in the case, but this is not an evidentiary hearing. No one is making a finding of anything at all other than whether it's appropriate for you to have a bond, okay? All right, Ms. Beck, when you're ready.
Thank you, Your Honor. Ms. Rasheed is 49 years old. We do have a good address for her, and it is the address that is on file on Fairburn Road. She lives there with her 2 daughters, Jasmine and Yasmin, who are 10 years and 3 days apart. She wanted twins, but that's what she got. It was pretty close. She has
10 years apart, but is one of them 1 and one is 11 or
one is
30?
23 and one is 13, Your Honor. She is a lifelong resident of the state. For most of her life, I should say, because she did serve in the U.S. Navy for 5 years, from 1998 through 2003. She was on active duty. She was stationed at both the Great Lakes, and then she went to San Antonio, Texas. While in the Navy, she was in the police force, serving with the Air Force, actually. Most of her family lives here in the state. She did attend some college at the Georgia Medical Institute, as well as Atlanta Tech and the Art Institute of Atlanta, where she studied culinary arts. She's currently retired from the U.S. Navy. We would be asking for a bond not to exceed $50,000, Your Honor, based on her lack of criminal history. She is going to show up to court when summoned. She is okay with an ankle monitor. We would just request that it would be paid for by the county. We would be asking for $45,000 on the 1 count of felony murder and $5,000 for the abuse of an elderly person.
Is Ms. Rasheed, you said she's retired from the Navy. I heard that. Was
Yes,
she
Your Honor.
working before she went into custody?
No, Your Honor. She's been
Okay.
retired for some time now.
And the different schools she's gone to, was that all in the past or that was more recently?
That was all in the past, Your Honor.
Okay. So she finished her naval service in '03. That's 21 years ago.
Yes, she recently retired, Your Honor.
From what?
She told me that she had retired from the US Navy. I believe she still gets benefits from them.
Okay. But I thought that she was in the Navy only from 98 to '03.
That's correct. Yes, Your Honor. Did you have anything more recent?
No.
There's nothing more recent, Your Honor.
Okay. Ms. Rasheed, have you worked since 2003?
Yes, sir.
Doing what?
I was actually working through the military, from the military. I have vocational rehabilitation and I work with Tommy Nobis Center.
That's okay. You need to, there you go.
I apologize. You're okay.
I worked with Tommy Nobis Center and that was with the disabled veterans as well through the vocational rehabilitation program.
Okay. All right. Thank you. Mr. Rao.
Yes, Judge. With respect to the defendant's criminal history, it does not appear that she has any. It does appear from my review of her GCIC and NCIC that this would be her first arrest. What I will say, and the only reason I'm bringing up the facts is because the defendant made specific statements that on its face, when looking at the incident, would not appear to be true. And I would just ask the court to take that into consideration. When the officers arrived at the scene, they observed the victim, who was born in 1947.
Was the scene the Fairburn Road address where Ms. Rasheed would be going back to?
That's correct.
Or different? So this was her own home?
That's correct. Her mother was living with her under her care.
Okay.
And when officers responded to the scene and observed the victim, who was deceased at that point, they observed number of sores consistent with being there for a long period of time. And in addition to that, they observed feces that appeared to have been there for an extended period of time, to include insects and larvae. And the reason I bring that up specifically is when asked about this specific, her care of her mother, she said that she took care of her daily, gave her sponge baths daily, and provided general maintenance, as I guess she would be required to do as her caretaker. And the physical scene itself would seem to contradict every one of those statements. And one, putting the defendant back in the incident location and potentially having another, her 13-year-old daughter under her care, would bring grave concern to the state. And I think that is a factor when considering danger to the community, her own family, our community members. And there's evidence to indicate that there could be danger to them. So I understand this is not the typical defendant that we deal with respect to these charges, but I am going to ask the court to deny bond based on the state's perspective of the evidence so far.
So this is a question for either one of you. I know DFACS is for children, and I think it's APS for adults. And so it really wouldn't be an APS question. But has someone done an evaluation as to how safe it is for, which is the 13-year-old, Jasmine or Yasmin?
Yasmin.
Yasmin, how safe it is for, thank you, Yasmin, to be under the care and control of Ms. Rasheed. And I'm not asking Ms. Rasheed's opinion. She'll say, I can take care of her, but we've got some objective facts that say caregiving may have been a challenge for someone under Ms. Rasheed's care. Jasmine, I'm less worried about, assuming she is an able-bodied individual. She's 23 and she can do what she needs to do. But Yasmin, that's a different situation. And I would feel more comfortable if I knew that someone from a support agency had evaluated that that's a good situation for Yasmin.
Yes, Your Honor. In regards to Jasmine, my understanding is that she is able-bodied, so there shouldn't be as much concern with her. Yasmin has been living with other relatives in the state of Georgia since her arrest, and I assume that she could continue to live there. She could continue to live with the other relatives until we get the situation figured out.
And how does that work? I want things to be as non-disruptive as possible for Yasmin. Has she had to change schools because she's living with other relatives?
No, Your Honor.
Where does she go to school?
Where did she go to school?
Atlanta Heights Charter School.
Atlanta Heights Charter School, Your Honor.
Okay, and she's still going there since you were arrested? Okay,
On 8th grade in middle school.
She's in 8th grade in middle school, Your Honor.
okay. And whoever she's staying with is able to get her to that same school?
Yes.
That's correct.
All right. But Jasmine remains at the Fairburn Road address.
Yes, ma'am.
Does she work?
No, not at this time. Actually, she just graduated college twice.
Good for her. What is she hoping to do?
She wants to work in her field, within marketing field.
Marketing, okay.
Sir.
All right. Ms. Rasheed, I will set a bond. I'm going to set a bond of $50,000 for count 1 and $10,000 for count 2. So it's a $60,000 bond. That is a bond that you or people who are supporting you can post through the Sheriff's 10% program. That means that when your case is resolved, much of the money that was posted can be returned to the people who post that bond. You will, at least initially, wear an ankle monitor paid for by the county. We'll review that if 3 months have gone by and there's not a change, your case still is not indicted, and there's nothing new going on. I will ask Ms. Beck to flag that for me. Your case will stay with me as long as it is unindicted. Once it gets indicted, it'll be randomly assigned. There's a 1 in 14 chance it'll come back to me. So I'll be handling bond issues. The flip side of that is if while you're on your ankle monitor, you violate some condition, that'll come back to me and we'll deal with the bond revocation issue. Yasmin will need to not live in the same place that you're living. So it sounds like you're going to go home to the Fairburn Road address, and I'll need that. You just email it to Ms. Nelson and we'll put it in there. That's going to be where you're required to live. If you want to move, you have to get the green light from pretrial services about that new address. You'll say, I'm thinking about moving to Smith Street, and they'll make sure that's an okay address. But wherever you're living, Yasmin cannot be living there. That doesn't mean you can't see her, but you may have no unsupervised contact with Yasmin. So there's got to be another adult around when you are spending time with Yasmin. Not cohabiting, she lives wherever, and you're going to work on that with relatives. She doesn't live with you, but that doesn't mean you can't have dinner with her sometime. Make sure she's doing okay. But she's going to be under the direct care and supervision of someone other than you. We can always revisit that if things are dragging along for too long as well. But for now, it will be a condition of your bond that you have an ankle monitor, and unless and until you've got a job or something that requires you to be out and about in the evening, you'll have a curfew of 8 p.m. to 8 a.m. So you are at home from 8 p.m. to 8 a.m. 8 a.m. you can be out and about doing what you need to do or want to do. And then I mentioned the no unsupervised contact with Yasmin, who needs to live in a different residence. Any other conditions, Mr. Rao, you'd want to see on the bond?
No, Judge, I think the court covered it.
Okay. Anything else, Ms. Beck?
No, Your Honor.
All right. Ms. Rasheed, if the bond I set is out of your financial reach, Ms. Beck will get in touch with me, not tomorrow or the next day, but if enough time passes and it's clear that you are not financially able, with the support of friends and family members, to make that bond, then I'll think about whether it ought to be lowered. I don't mean for it to be an impossible bond, because I would have just said $1 million cash. But I do mean for it to be a meaningful bond. As I said at the outset, these are serious charges, and we need to make sure that you don't have any inclination to avoid them. You're going to need to deal with whatever the state indicts you for and stick around for that. So that's why I'm making it a fairly significant bond. If there's nothing else, Ms. Beck, that's it?
Yes, Your Honor. I'll walk you over there, okay? Yep.
I say.
Oh, it just hit. Okay, good.
Awesome, Michelle. Okay, so I need to.
Yeah, I checked it. I don't have an answer. Yeah, so I'll write it back. All right, should we handle Ms. Fields?
Yes, please, Your Honor.
Okay,
And then I already did explain to Miss Israel the situation about her bond.
great. Thank you for doing that. Oh, okay, let me do these things. We can bring Ms. Fields out, take care of that.
Always.
So,
Oh, some trafficking. It's all manageable. Good. Good seeing you.
Thanks, sir.
Take care.
Yes, I see.
Yeah, yeah. All right, let's get on the record in Ms. Fields' case. It's 24 PI 006766. Good morning, Ms. Fields.
Good morning, sir.
Ms. Fields, I'm Judge McBride. We've not met before. Your case has been assigned to me just for purposes of bond. You have a pretty serious charge in the form of murder, and the magistrate that you met maybe 24 days ago isn't authorized to consider bond for a charge like that, but I am. And as long as your case remains unindicted, I'll be the one who's working through bond issues. So I may set a bond today, I may deny bond today. That's not necessarily the final word. If we get to the 90-day mark and you don't have a bond, then I have to set a bond because the state only has 90 days to have someone held with no bond without indicting them. But I may set a bond today. I don't know enough about the situation other than you're alleged to have shot someone in the head in a U-Haul truck. But we'll talk about that. So I'm going to hear from Ms. Beck, and she's going to tell me why I ought to set a bond and what that should be. And then I'll hear from Mr. Rao, the prosecutor, and we'll take it from there. Ms. Beck.
Thank you, Your Honor. Miss Fields is 38 years old. We do have a good address for her. It is in Stockbridge, Georgia. It's different than the one on file, but I will obviously provide that to Your Honor if you request it. She will be living there with a friend. She has lived in Georgia since 2015. She was actually born in Georgia. She grew up here in Carrollton. She moved to Florida for a few years and then came back in 2015. She does have 2 children, both of whom are in foster care, or I'm sorry, she has 3 children. One is living with a relative in Alabama. 2 are in foster care in Georgia. She did attend college. She has a degree in communication arts, technology, and graphic design. She also has another degree in marketing and communications. She received that degree from Purdue. She is disabled and is actively trying to get SSI. She did want me to note that she is currently in the New Beginnings program at the jail. She's being housed at ACDC. She is attending counseling. She's gotten parenting classes and anger management classes. She is also attending domestic violence counseling. She's had no problems while at the jail. We would be asking for a bond not to exceed $75,000, Your Honor. Oh, in addition, she is also okay with an ankle monitor. She would just request that it's paid for by the county.
All right, Ms. Fields, this friend you'd be staying with in Stockbridge, who else lives in that house?
Just them.
Just that one person?
Yeah, just them.
Okay, how do you know this person?
Through mutual friends. It was one of my husband's friend.
It was one of her
Person
husband's
you'd be
friends.
staying with is
It was-
someone who was a friend of your husband?
We were all friends.
You were all friends, okay? And does this person know that you are hoping to stay there if you get a bond, or will this be a surprise to that
No,
person?
no, they know. I talk to them on the phone almost all the time.
Okay, and this person said, it's okay, you can stay with me?
Yeah, I'd be willing to go into a program or whatever you guys recommended though also, sir.
Okay, all right. That may be a little ways down the road, but I appreciate that, and I appreciate that you're already engaging with the folks at New Beginnings. You are hoping to get, have you received disability payments before, or this would be the first time?
No, sir. I was hit by a forklift while I was 35 foot up in there on a scissor lift on my dad's job as an electrician. So that was in 2019. And I've been doing all the surgeries and stuff. And then I found out October 22 that I would never get better. So then I filed for disability and I have it all in the process. It's all a process.
And is the disability a physical disability or a mental health disability?
It's a physical disability that I filed for, but it's really both.
Okay, all right. Mr. Rao.
Yes, Judge. The defendant has 4 prior felony convictions, 2 out of Florida and 2 out of Georgia. The 2 convictions from Florida, a 2007 burglary conviction, as well as a 2009 aggravated battery on a pregnant victim. And then the subsequent convictions in Georgia are possession of methamphetamines out of Henry County, for which she was convicted of that charge in 2017, as well as a serious injury by vehicle and DUI charge out of Clayton County, for which she was also convicted in 2017, for which she specifically received 10 years on probation. So at the time that this offense allegedly occurred, the defendant was on felony probation. I will also bring up, in addition to that, the possession of methamphetamine charge she was arrested for on May 7th, 2016, and subsequently bonded out, and then was arrested on the serious injury by vehicle DUI charge approximately a week later on May 13th, 2016. And the reason I bring that up is if the court does, in fact, issue a bond and assess conditions, the state believes that based off that particular history that the defendant would violate the court's instructions, having picked up an offense while out on bond, and would be a risk to reoffend given her 4 prior felony convictions in this particular case. In addition to that, Judge, as alleged in this case, the defendant is alleged to have shot the victim in the head while inside a U-Haul and subsequently disposing of his body on the side of the road before fleeing the scene. That has been corroborated 2 ways. One, by the U-Haul records that the Union City Police Department was able to obtain, indicating that the defendant did in fact rent a U-Haul, as well as a witness coming forward to the police and indicating to the lead detective that the defendant confessed to her, indicating that the victim and her were in a physical altercation, at which point in time she brandished a firearm and shot him before disposing of his body. There are members of the victim's family that are present, and I believe there is a prepared statement that you all would like to read. Okay.
I just said, sure, we would like to address the court.
So at the court's pleasure.
Okay, so I'm happy to hear from each of you or a overall spokesperson, however you want to do it. What I'm going to ask you to do is come over to where Mr. Rao is. And if you'll sit between the 2 lawyers and use the microphone there, I'd appreciate that. Gonna be very in there. We'll go one at a time.
It's not long, can we each do one?
Sure.
One person there. Sit between you.
You said.
All right, I need you to give me your name and then you can share with me whatever you want to share.
My name is Gerald Parch. Your
Good
Honor,
morning, Mr. Parks.
I stand before you today to address the issue of bond for my stepmother, who has been charged with the murder of my father. This is not just a legal matter, it is deeply personal and tragic. First and foremost, the nature of the crime is horrific. Taking a life is an irreversible act. And my father's murder has left a mark on our family. Allowing her to post bond could pose a danger to the community and undermine the seriousness of the crime. For the sake of justice and to honor my father's memory, I urge you to consider these factors carefully. My stepmother should not be granted bond. Thank you.
Thank you, Mr. Parks. How old are you?
15,
Where are you going to school?
Griffin High School.
All right, I appreciate you being here.
Thank you.
Good morning.
Good morning.
And you are
I'm Judson's sister, Shannon Garrett.
Shannon Garrett.
Yes, sir.
Okay. Good morning, ma'am.
Good morning. I'm here today for my brother Judson because of Alana's actions and the choice she made to take him from us. My family will never be the same. I am here speaking for myself, his children, nieces and nephews, my husband, Travis, cousin Stephanie, and even her mother. I've spoken with her and the rest of his family. I will never hear "I love you, sister," or his goofy laugh when he's trying to make me smile. We will never hear "hello, cuz," brother-in-law, or Uncle Judd loves you. There are no words to describe the pain her actions have caused, knowing he is gone forever, or the thoughts of the last moments of his life. There was a comment made that no one even cared enough about him to look for him if he disappeared. Well, we are here today to show just how untrue that statement was, and that there are so many people who loved him and will feel the pain of his death for the rest of our lives. Myself and his loved ones are asking that the court please deny bond for Alana for her actions. In addition, we do feel that somewhat concerned for our family's safety if she's granted bond. And we'd just like to thank the courts and the law enforcement and everyone for helping bring justice.
Thank you, Ms. Garrett, for being here and sharing those comments. I'm sorry for your family's loss. Mr. Rao, anything else?
Nothing from the state, Judge.
Okay. Officer Evans, do you have any information about probation and Ms. Fields?
Yes, Your Honor. As stated, she is on active probation for that 2017 conviction for injury by vehicle and possession of methamphetamine, and that is set to expire August 26th of 2027. There is an active probation hold from these current charges.
Okay. All right. Thank you, officer.
Yes, Your Honor.
Ms. Beck, anything else on behalf of Ms. Fields?
Yes, Your Honor, just briefly. I understand what the state said about how she had gotten new charges not even a week after she had bonded out on that 2017 case. However, that I would say that was 7 years ago. A lot has changed since then. Ms. Fields has changed since then. We would still just be asking for that $75,000 bond. Again, she is okay with the ankle monitor. We would be okay with a stay away and no further contact from any of his family. We would just ask the state, or we would just ask Your Honor for that.
Ms. Fields, at this point, I'm going to deny bond. I have concerns for your safety, as well as the safety of others. This is still a very fraught situation, given the connections that everyone has. I am relieved that you are engaging in some self-care at ACDC by plugging in with New Beginnings. I encourage you to keep doing that. I think you need some support in certain aspects of your life, as I hear about the criminal history and what was going on more recently. But I think that the best way to ensure the safety of the community, your safety, and your continued appearance in court is that I'm going to keep you where you are. Now, a couple things on that. If you are not indicted within 90 days, then you are statutorily entitled to a bond. And so on day 90, 89, 91, thereabouts, Ms. Beck would be reaching out and we'd have another conversation and I'd be required to set bond. And I'll do that if the state hasn't done what it needs to do within that time frame. If you are indicted, your case will be randomly assigned to one of 14 judges. That could be me, it may not be. And you will likely have another lawyer who's then assisting you. And that lawyer can talk with that judge about bond as well. So my decision today of no bond isn't the final say, it's my say for now. If we get to day 90 and you haven't been indicted, then I have to set a bond. If you do get indicted 2 weeks from now, there's no reason why the lawyer, who's a law associate of Ms. Beck's, can't say, well, we've got another judge. Now we know what the official charges are. You've been indicted. Let's check with that judge to see if bond is appropriate. And that judge doesn't need to follow what I did. I'm not that judge's boss. So there will likely be another conversation about bond, either with me as we get to day 90 or with that other judge. Mr. Rao, anything else?
No, Judge.
All right, Ms. Beck, thank you for your service.
Judge, may I be excused?
Yes, sir.
Thank you.
Thanks for being here. All right, I gotta tackle one presiding thing, just right here on my screen. What are we gonna do after that?
On Mr. Suttles.
Okay,
May I be excused, Your Honor?
yes, ma'am, thank you. And what about Michael Reynolds?
We are still negotiating on that.
Okay,
Um,
and Mr. Gomez I met with, oh, we've got Mr. Williams. Are you here this afternoon or not? Okay, it may be just timing wise that we talk to him in the afternoon.
that's all. Ms. Granovic has spoken with him as well. And Ms. Peterson is printing some stuff off. So Mr. Williams can have that as well.
Okay.
So no rush on that.
Okay, great. If you weren't gonna be here this afternoon, I'd try to fit it in, but I just wanna have a little flexibility with that. So you're working on Mr. Reynolds. Why don't you just give me the announcement on Mr. Suttle so he doesn't have to stick around, and then I'll turn to the presiding matter.
This is already, well, the first two cases are already on the November 14th trial calendar. I'm just gonna ask if we can hold off on the final plea hearing and just keep the rights reserved. This should be a global resolution. We're just trying to get all of our ducks in a row.
Okay, do you have any objection to that, Ms. Nix?
No, sir.
Okay, and should we, even though it's a new case, should we fast track the 24 SC to be as an, I guess it doesn't need to be added to the trial calendar. The other two are on it. And the state would just need to be ready to try one of those two rather than the third one, if for some reason it's not a global resolution. Does that make sense?
Yes, sir. Because we're still at P and A, though, I haven't gone through discovery and sent it, so.
For position 3.
Yes.
Right,
Sorry.
no, understood. That's why that the trial calendar will keep positions 1 and 2 on it. All I'll do is preserve final plea rights. We won't add 3 to the trial calendar as a triable case. It will just sort of tag along. Presumably, if Mr. Suttles wants to work out the first 2, he'd want to work out the third as well. It just makes sense if it's something that everyone can have a meeting of the minds. And it can still be a blind plea off the trial calendar, but he'll have his final plea rights. So he could say, oops, no, that's not what I want to do. I'm just looking at all 3 of them. Okay. And if you sort it out before then, let me know that and we'll take care of that.
Thank you, Judge.
All right, Mr. Suttles, any questions about that? All right, then I will see you at the latest, the day we call the trial calendar. And we'll see if it's worked out. It may be before then things are worked out and there's no need to wait that long. That's a long, messy day and you'll be in a long line to work your case out. So you'll get relief sooner if you guys sort it out sooner. All right, Ms. Nix, anything else?
Yes, sir.
Okay, great. Then why don't you keep talking about Mr. Reynolds? I think that's all we've got left other than Mr. Williams. So I'm going to turn to my passport situation. Miss Gums, how are you?
Okay.
Good. You are trying to travel abroad to have your son go back to school?
Yeah, back to school. It's my grandson, but the passport office just called to make sure that we're still gonna try to make it back.
Grandson.
Her daughter is out.
My daughter.
Oh, you are not Anisha.
No, that's.
Okay,
The passport office just called on.
okay, so she's here.
Yes. she's
Got
here.
it. All right.
But
And so, what do we call your grandson?
we call him JJ.
JJ.
But his name is James.
I see. So JJ is a student in
Anguilla, yes.
Anguilla.
Yes.
What's he doing here now? I mean, it's October.
We just bring him, he's autistic, so we just bring him up once a year for him to go and see his regular doctor, Dr. Drayton.
Got it. And so he's had that appointment and is
Yes.
trying to get back home
Yes.
and go to school, and his passport's expired. Because the little picture, he's a teeny kid in his
Yeah,
passport.
He's 5 now, but you know, he's very smart, but his father unfortunately has not played a part in it.
Yep,
But
I see that.
we did reach out to his dad, which tried to reach out to him, and he actually told his dad he was gonna do it, but he didn't do anything. But he doesn't fight us for anything,
Okay,
you know?
all
But
right,
at the same time, my daughter is in medical school down there too, that's why she's also there.
okay.
She goes St. James Medical School in April.
Is this your daughter?
Yes.
Hey, how are you?
Good, how are you?
All right, so JJ is trying to get with you back to Anguilla to go back to school. Okay, I've signed what I think you need. We'll see what happens. I'll give it to Deputy Gordon, and I wish you luck.
Thank you so much.
All right.
She has been crying all along.
Don't cry. I know this is stressful. Next time, don't wait till the last minute either. Check on that passport.
We thought he had already sent it.
Oh,
Because he did say yes, so all I had to do is check the mail when I got here.
oh,
I did,
and he didn't do it.
he does not respond.
Okay, all right. Well, good luck. I hope it works.
Thank you so much.
Yeah.
So you don't go upstairs?
I think that's all I have until the activity comes.
Yes, you're good. Thank you. Mr. Thomas, how you doing? You trying to do a legitimation? Great, I've signed the affidavit. All that does, I mean, it helps, but it's not gonna get you your ultimate goal. Just means you don't have to pay the filing fee. So with that, you should be able to, whatever you're trying to file to start the legitimation process, you should be underway. Good luck. Oop, you probably want this too. Thank you. I like those doors. That's crazy. Mr. Williams? How are you, sir? So your truck is stuck? They won't give it back unless you pay the impound fee?
I mean, they sold it.
Oh, they sold it?
They notified me.
Okay. Got it. Okay. Well, I've signed the document that will let you file your lawsuit without having to pay the filing fee. And we'll see where that goes, okay?
Thank you, sir.
Good luck. Sorry about your truck. That makes sense that it got continued.
Yeah, it does.
So we're gonna probably, well, not probably, given what time it is, we're gonna have the conversation with Mr. Williams this afternoon. I'm back at 1 to do what? Hear a couple of 404B, but they're short ones. I don't think they're evidentiary ones. So we'll do it then. If you don't, I'm sorry to have you keep popping back in there.
It's not a problem, Judge. So 1 o'clock or 1:30?
Why don't we say 1:30, because I'll start with the actual scheduled 404B. I don't think it'll take that long, and the next one is at 1:30. But if I can pull that ahead, I'll do it. So if you'll be here at 1:30,
Absolutely.
that would be great. Thank you.
Thank you, Your Honor.
You bet. Ms. Rutland, is there a big gap between the two parties? I want to give Ms. Wood all the time she needs, but as we approach the noon hour, I got to go to a meeting. We're going to run out of time for this morning. We can always tackle it in the afternoon. What's your sense? Oop, here comes an answer.
Okay.
Hold that thought.
Okay.
So Mr. Reynolds says he is not wanting me to represent him.
Oh,
So if I don't know if the court wants Ms. Primovic to try to talk to him. I'm sure what's happening is he's in the back with Mr. Williams. So
that's toxic. So you tell me, I'm happy to have an initial conversation with Mr. Reynolds right now. We got 10, 15 minutes. And then Ms. Primovic could chat with him if she can circle back today. We'll keep him right here. But I'm happy to handle it. Or we can let him stoop and Ms. Primovic can come later today if she's able.
he got to referee back there.
I prefer to courts.
I think if you could talk to him, just let him know that
What is the landscape right now? What's the state's offer?
it's down to 10 served 1.
And how much time is it actually, he'd have to serve some time or he's,
Got some months built in.
okay, so he's done a chunk of it.
Yes.
He actually shot at someone? It's not just like I shot in the air or,
Correct, he shot at there was one named victim and her brother, and he struck the car. that they were
meaning
walking
the bullet he shot hit the car?
Yes,
And you're offering just one?
yes.
Okay. So, yeah, if you don't mind bringing Mr. Reynolds out, he can just come right to the podium.
And Judge, just as a preview, I anticipate that he will want to talk to you. I reminded him that the judge does not get involved in negotiations. But I do expect that's gonna be a bit of what he wants to.
He wants to haggle? Okay.
Yes.
What's the hate angle?
The hate crime enhancement notice actually wasn't filed in this case. However, if it would have been, what happened was he doesn't know the victim. The victim's brother was in his apartment and the victim went up to the apartment to try to get her brother. And she's a transgender woman. And he said, I don't want all this transgender
Got it.
things outside of my home. And that's when he got upset and shot at them.
Okay.
What we doing with
We're gonna talk with him after the lunch break. Ms. Peterson came back while you were back there. I told her just be here at 1:30. And we'll just leave it in between. Hey, Mr. Reynolds, you just come right to the podium. I just wanted to chat with you real briefly to get an update about what's going on. Ms. Wood came out here and said, no, we were negotiating. I thought we might be heading in a direction. And then she was surprised to hear from you that maybe you want to represent yourself, or she didn't use those words. She just said that maybe you didn't want Ms. Wood to be representing you. But unless you're hiring a lawyer, you don't necessarily get to pick who your lawyer is.
Yes, sir.
You can have any lawyer you can hire, you can represent yourself, or you can be very, very ably represented by Ms. Wood, who is the senior public defender in this courtroom. But
Okay.
I'm not putting words in your mouth. I just wanted to get an update from you. Let me tell you what today is procedurally,
Yes, sir.
and then I promise I'll listen to you. Today's your final plea date. So what that means is today is the last day you could enter a plea. And if you don't like the sentence I give you, you can withdraw. No questions asked. No one ever knows about it. It's just, we gave it a try. You thought maybe through my lawyer and through me, meaning you, I'll be able to convince the judge that this is the right sentence, even though you know the prosecutor might be asking for a different one. And if I end up either agreeing with the prosecutor or thinking that's not enough, it should be more, or in any way exceeding what your lawyer asked for. So let's say, how long you been in?
I've been here in Fulton County Jail since June 6th. So.
Okay, so 6 to 10, 4, you've been in for more than 4 months. So maybe Ms. Wood says we'd like time served. And I hear the situation and what the allegations are. And I say, you know what, it should be more than that. And I say, I'm gonna give you 6 months. That's more than time served. You could withdraw your plea if you want, because what I sentenced you to is more than what your lawyer asked for. And all that means is that you stay on a trial calendar. You can always have a trial. The jury will hear about what happened and they'll decide guilty, not guilty. Of course, after today, this is the big change. After today, you can still enter a guilty plea. You may not want the jury to hear all about facts of the case, and you may want to take a plea. And you can do that. You could do that in the middle of trial. but you don't get to withdraw your plea if you don't like the sentence you get then. Today, Judge, I'm backing out of this, and I say, all right, I respect that. That's your call today. After today, if you try to plead tomorrow, or the day of the trial calendar, or once the 50 jurors walk into the courtroom, you can plead then, put them all out of the courtroom, and I'll take your plea. You just don't get it back out of the plea. So if I were to give you 6 months or a year or 2 years or 100 years or whatever, I don't know anything about the case to say, here's what I do. That's just like at trial. Of course, if you're found guilty at trial, you don't get to say, I'm not taking that sentence. You would have rolled the dice. 12 people would have heard about the case. And if they find you guilty, you face the music of whatever sentence I think is appropriate after I've heard a whole lot more about the situation than if we're just doing a plea. Because with the plea, the prosecutor says, here's what the case is about. Your lawyer said it's more complicated than that. And here's what's going on. And I handle it. So I spoke for a long time. Tell me what's on your mind.
Yes, sir. Judge, I just want to read this report to you so I can really make you understand what this report was said about me.
Tell me what the report is before you read. This is the police report?
Yes, this is the incident report from the police.
All right.
So is it okay if I read it to you?
It is. Just read slowly so the court reporter can take it down. It's not a million pages, is it?
No, this is the first page.
Okay.
And it's like a short paragraph.
Okay. Read me slowly the short paragraph.
Okay. On 04/29/2021, I, Officer D. Irvin, was dispatched to a shots fired call at 11:97. Period. Upon a with Ayanna Clark, and she advised that she brought her friend Larry O'Neill over to 1197 Joseph E. Boone, apartment 21, to visit one of her friends. I don't know that person. Ayanna advised her friend went into apartment 21 and she stayed. He stayed into the apartment in her vehicle, and Ayanna advised that she's going to go for a quick visit, but her friend was taking too long to come out the apartment. Ayanna advised she got out waiting too long and got to her vehicle, got out her vehicle and knocked on the door apartment. You see, all this is like stuff thrown around. Then Ayanna advised that a tall black man, light-skinned complexion with glasses, with a white t-shirt. Who is that?
I don't know. I'm not the officer who wrote it.
I understand, but they saying this is the identification that they putting on me, saying that I am the light-skinned guy. I'm not even light-skinned.
Okay. I wouldn't describe you as light-skinned. You do have glasses.
And I have dreads. It's not even this in the report.
Okay.
Also, Ayanna advised that the mail said, I don't like all of this stuff in front of my house. It's an apartment. Ayanna advised that she walked from the car towards her vehicle when she was in front of my house, supposedly. Okay. Ayanna advised that when she got next to her car, that the unknown male was supposed to be me, the unknown person she don't know, that she just seen, that person that's supposed to pull out a gun and shot at her. Who is this unknown person?
Okay.
Okay, to even make it long story short, sir, I've never even known this person. And at the end of it, it says there was no witnesses available to provide for further incident.
Okay.
But you said you brought Larry O'Neill with you. Who is this person that you have? Don't he supposed to talk to the police too?
So you have one report that was written by the responding officer. I don't know what else is in discovery. I don't know if the different people that you named in there, you didn't name, the officer named, have given statements to the prosecution. That they met with him and said, actually, it's not an unknown person. I know him as Mike, it's Michael Reynolds. I'm making all this up. I don't know. But I promise you this, there's more to the case than that initial report. That is an officer who writes a dozen reports each night. As you figured out yourself, that poor officer didn't write in real clear terms because one of the sentences was she walked from her car to her vehicle. I said, are you walking in a circle? And what does that even mean?
I don't even get the understanding of that.
But you don't need to, because that's not what the trial would be about. The jury will never, ever see that piece of paper. That's not something that the jury would see. The jury would have the officer who responded. He'd say, hey, I got to the scene and this person said X or Y, and there was a bullet hole on the side of the car, and I took down some names. And then presumably there's a detective who worked in this case, because that's the one who would start connecting some dots. If the only thing the police had and the prosecution had was that report, that could be any light-skinned male in a white t-shirt.
That's exactly.
And so what is that? 50,000 people, 100,000 people? I mean, all sorts of it. So I suspect that there is more in discovery that the state believes connects you to that situation. And that's what you ought to be talking to Ms. Wood about. So what do they have beyond this police report? And if she says there was this witness statement and there's body cam and this and that, you should be listening to her about that. Because if you're clinging to that saying, boy, we should go to trial because that's all the state has, I think trial's going to be a rude awakening for you because they wouldn't have indicted the kid. There's no way they could even know it was you based on that police report. It's an unknown male. That means that you, who knows? So I wouldn't put a lot of weight in that initial report. That's how cases often start, where there's an unknown suspect. And then they bring in a detective and maybe they learn that the unknown suspect drove out of the apartment complex soon thereafter on Joseph V. Boone. And they look at the flock camera and say, hey, the only car that left was a white Chevy Malibu, license plate 12345. Oh, that belongs to Michael Reynolds. There's a clue. And they investigated that way. All this I'm making up because I don't know anything about your case, but I do know that I occasionally have conversations with well-meaning defendants who say this police report is garbage. It doesn't say, it doesn't connect me to it at all.
But mind you, you know, I was never arrested for anything of this nature.
So how did you end up? I mean,
they had this, a reason why they got me is because I am the private person who paid for the apartment. They do have identification of me. So that's why they had to say that it's supposed to be me and it wasn't really me.
Okay. Well, you may have a good defense then. If you've got a good defense, you shouldn't plead. You should go to trial.
I'll take it to trial.
Well, I'm gonna ask you to do one thing.
Yes, sir.
Because it is your call, whether you go to trial or not. It's not Ms. Wood's call. But I know you and she were in the middle of a conversation. I don't want you to be influenced by the folks who are back there who have very different situations.
Yes, sir.
So I'm just gonna have you two close the loop. And if your decision is
I'll
you
go
wanna
to trial. I'm saying I'll go to trial.
Okay.
I'll
So
go to
let
trial.
me just get this, clear.
I asked her also to sit up and try to get me home to my mom. I keep saying to my mom is sick.
Yeah.
The lady smiled at me and hee ha ha. I don't want her to work on my case as well.
Well, my guess is she wasn't laughing about your mom's situation, if that's what happens, because that's not my experience with Ms. Wood. But unless and until you hire someone or say you want to represent yourself, which is rarely a good idea, Ms. Wood is your lawyer. You guys need to sort out whatever the misunderstanding was about your mom. You're not going anywhere to see your mom or anyone else till your case is resolved, but you're on the upcoming trial count.
I'll go to trial,
You
sir.
told me you want to go to trial. I just need to make sure you understand that after today, if you have a change of heart and want to enter a plea, you can do that. You just don't get to withdraw your plea if the sentence that I impose is different from what you asked for.
Why would they give me time for something I haven't even done though?
Well, that's why you should go to trial. You
Okay,
shouldn't
I'll
do
take the
time for
trial.
something you didn't do. Okay? So is this on the November 14th calendar?
Yes, Judge.
So at the latest, Mr. Reynolds, you'll be back here November 14th for the trial calendar. If something changes between now and then, and maybe the state looks at the case more and says, "Ooh, how about misdemeanor time served?" All this stuff I'm making up, you may say, well, I'd rather take that time served. I can go home and I don't run the risk that the jury is going to get confused and say, I'm guilty of shooting at this car. And then you're looking at some years. So something could change and you might see me sooner. But if that doesn't change, then we'll see you for the trial calendar on the 14th.
But I was already told that I was getting, y'all was coming at me with 10 years already to do 5.
So I'm not coming at you with anything. I'm a judge, and I would only deal with sentencing if you plead guilty or a jury finds you guilty. The prosecutor who's sitting behind you there, that may have been her initial offer. I don't know. I don't get in the middle of negotiations either. And so you may think the state is way out of line with its recommendation. And your response is, I'll see you in court at trial. You may say, here's a reason why you should come down. Ms. Wood will communicate that. And if they were at 5, it sounds like they've come down some, but who knows what happens. That's for the lawyers and you, and I will see you, like I said, at the latest on the 14th.
Could I have another case manager?
Lawyer?
Case manager, lawyer.
What do you mean by case manager?
I would like to trade another one.
So you don't get a trade. It may be that Ms. Wood, who's got some colleagues, has a colleague chat with you some, because if there's a trial, there are usually two lawyers, who will be handling your trial. Ms. Wood will be one of them, but she may have a partner in there, and that may be someone you're a little more comfortable with. But my request of you is that you be open-minded and working with Ms. Wood. She is a better lawyer than you'd be able to pay for by far. But I'm gonna repeat what I said earlier. If you are able to hire someone or your family hires someone, that person can parachute in at
Judge,
any
you know
time.
I'm not able, because when you gave me that $30,000 bond, I told you I wasn't able to pay
Okay,
that.
then you remain someone who needs to have appointed counsel, and that's who you've got. So I will see you on the 14th
Okay.
if it's not worked out before then. Thank you. Well, all right. I will see some of you, not you, Ms. Rutland, thank you for being here. But I'll be back, pretty close to 1. And we've got those 404Bs or pleas, whatever's gonna happen with them.
Yes.
We'll weave Mr. Williams into that as well. Ms. Peterson will be here around 1:30 for that. Okay?
Thank you.
You're having a great day.
Over to you.
Yes, Your Honor.
All right, I'll see you guys soon.
Yes. Well, a couple of things. First of all, I think we need to have some more specific information about that previous case. And we're being told that it was some type of robbery, that we believe it involved a gun, but there are a whole lot of different ways that a robbery can occur. And this could have involved, from what we've heard, we don't know. This could have involved a store, this could have involved a person. It's our contention that this was, that what he pled guilty to at that time did involve a person in a way that was completely unrelated to anything that we're looking at right now. So there has to be some type of connection between, if we're going to be bringing in a prior bad act, there has to be some type of connection between that and what he's looking at right now.
When you say connection, you know, it's not similar transactions anymore. So the touchstone isn't so much, gosh, it was a quick trip and it was at night and he wore a blue hat. We're not looking for those kinds of things. But maybe to your point, if the Gwinnett case was what we call a mugging, someone's just walking down the street and it's a person on person, give it up, take your wallet, maybe he had a gun, whatever it was, that is pretty different. Not from a similar transaction, but how does this show mistake, lack of mistake, intent, then going into a commercial establishment saying, I'm taking these things free of charge because I've got a gun and leaving? Those are not, I don't know that the intent to mug someone translates as readily into that the alleged convenience store robbery, as opposed to if the Gwinnett case were a convenience store in Gwinnett. And he said, I'm going to take wine coolers.
Yes.
Okay.
Yes, exactly. That's exactly what we're saying. That yes, there are robberies that can involve just two friends that get into a fight with one another. I've seen those happen. I'm sure the court has seen that as well.
Right.
That there are a multitude of things that could involve a robbery. The state has not shown, and I don't believe that the previous case did involve any type of robbery of any commercial establishment at all. So the only connection would be the use of a gun was used in this previous case. So once again, we don't have any information about the state has provided anything.
Okay.
So that would be our main contention right there, is that yes, there is not any specific information connecting these two. And then also if the argument is that it was any type of mistake, that we'd be trying to argue that a mistake was made in how the robbery was committed, which the state seems to be, that's part of why they'd want to bring it in, to show no mistake could have been made. That's not necessarily something we're going to be arguing. I haven't gone over everything yet. I'm still new on this case, but from what I've been looking at, I think we're probably going to be arguing a mistaken identity. That's not going to be in any way connected with what the state's saying right now. So if the court were to permit these prior bad acts being brought in, even though I, of course, would still disagree with it for the reasons I've already argued. But if the state were, or if the court were to bring that in, then I would certainly want there to be some limiting instructions, and it's only to be brought out if we attempt to make an argument directly related to it. So
Sure. So you're not committing to a defense, but your initial read of the discovery that you've got is that it would likely be mistaken ID, in which case intent's not an issue. Presentation to a jury, to a fact finder, would be Mr. Craig wasn't there. He didn't do this. So intent doesn't matter. The person who did this might have been confused, might have put money down, but that you have the wrong person. And so that's not, the state hasn't offered up identity as the reason for getting it in. And that would again be it's so similar. He wears a clown mask with one eye missing and walks with a limp. And like, okay, well, that would kind of show that the person who did it before, who we know is Mr. Craig because he pled guilty to it, is the one who did this one, even though he claims it was a mistaken ID.
yes,
Okay.
exactly.
All right, that's helpful. So Ms. Nix, for this case and generally going forward, if you're going to file a 404B, I'd ask that you get some of the basics of whatever the other act is. I mean, you had some basics, you knew what the plea was to, but some of the factual basics. So you could have answered my question of, it was a convenience store, or it was his cousin, and it was a big misunderstanding. He did take the cell phone, but it wasn't an armed robbery, and that's why it got reduced. More importantly, neither of us has a good sense of what were the basic facts of the Gwinnett case?
Yes, sir. All I have access to at this point is the warrant. So I
Okay,
apologize for that.
I bet that's not real helpful. So what I'm going to do is defer ruling on the 404B, give you, Ms. Nix, a chance to get a little bit more of the Gwinnett case file. Please share that with Mr. Wilson, and you can share it with me. You don't need to file a supplemental notice. But if there's a police report or you just want to write up a mini proffer, I didn't hear Mr. Wilson saying you need to bring witnesses in. He pled to it, but it's just getting the factual basis for that plea. Maybe it's the plea transcript, who knows? But that will help me assess whether it would come in under lack of mistake or intent. And then, Mr. Wilson, what I often do in a situation like you have now presented is that I would conditionally exclude it based on your representation that the defense is going to be mistaken ID. You are not bound to that defense and you may pivot. But if you pivot, I may pivot and say, well, now that you're arguing that, he paid for the stuff, then this could become more probative, the prior bad act. But it's not necessarily all that probative if the defense in this case is you have selected the wrong person from the photo lineup.
Yes.
Because then it's more propensity. Well, no, they had to pick the right person because look, he robbed a place before or robbed someone before. But let's see what Ms. Nix is able to pry out of the Gwinnett case file. Okay? Ms. Nix, anything else on the 404B?
No, sir.
All right. How much time would you like to track down those basic facts from the Gwinnett case?
You could give me 2 weeks.
Okay.
If I'm able to find a offense agency number, I usually request it. But
Okay. 2 weeks is fine.
Right.
All right, let's pivot to the bond discussion. Mr. Wilson, you are up. I don't know what the bond status is for your, it looks like he has a bond, it just may be one he can't make.
No, actually, it's a little more complicated than that.
Okay.
Judge, I can kind of summarize. So the defendant was originally arrested for just 3 of these charges. In indicting him, the state added a 3rd one, the possession of a firearm by convicted felon. I'm sorry, a 4th one, possession of firearm by convicted felon. He made bond on the original 3, and that was a total of, I think, $99,000. He missed court in May of this year, was arrested on the bench warrant, and Judge Ingram was filling in for Your Honor and granted a, reinstatement of his bond because at the time of the missed court date, he was in Gwinnett's jail.
One of the probation revocations?
Yes.
Okay.
And I don't know if he was in jail at that point on the probation revocation or one of his new charges over in Gwinnett, but he was released in July and was picked up on the warrant. I don't have the date in front of me.
But he has no bond on count 4.
Correct.
Got it. Okay. So tell me what you think we ought to do, Mr. Wilson. The bench warrant's been set aside, so I guess what Mr. Craig would be the no bond status on the possession of a firearm by convicted felon.
Yes. And first of all, something that I am still not completely clear on is, I believe what happened was that this 4th charge was actually added on after he had bonded out on these first 3. Is that correct?
Yes. I mean, he had bonded out and then he was indicted.
Right. So he bonded out and then this 4th charge was added. And that's why what we're asking for is an OR bond on this. And the reason we're asking for an OR bond on this is because he already bonded out on this event. He bonded out on those 3 charges that he was looking at that time. And then once he got out, everything was going fine, except for, of course, this one probation issue, which wasn't really his fault that he wasn't here. But everything was going fine, and then suddenly they just add a 4th charge and use that as a reason to lock him up again and tell him, well, now we're locking you up one more time. And making you make bond again.
Well, yes, they added a charge, but he missed court because he happened to be stuck in jail somewhere else.
Yes.
And that's why he's been locked up here. So it's not that the state rarely does this, that when there's a new charge added, especially when it's a less serious charge than the lead charge, like armed robbery, do they say, and we want a bench warrant or a grand jury warrant? That's really what it would be. It would be a grand jury warrant for count 4. They didn't. And there happened to be defendants wandering around who have bond on 3 of their 4 counts, but not on the 4th. That's not proper. We ought to fix it, but there's a bond. People are showing up. Your guy didn't show up because he got locked up somewhere else. So setting aside the questions about the propriety of bond for your client, if he's getting arrested while he's on bond in this case, we need to figure out what to do with count 4.
Yes.
And when you say OR bond, one, I don't think that's legal for that charge. So that would need to have some amount, but I'll look that up. But he should still be, I assume that the bond he made, Judge Manning in January of 2023 signed a bond order for, what is that, $33,000 and an ankle monitor. You still have an ankle monitor?
I was never released. From that. I've never been released to the streets.
I think he was transported directly to Gwinnett, and then from Gwinnett, he was released directly here.
Oh my gosh, so you've been in
Custody since 2022.
Wow. Okay. So maybe then what we do, the bond that could be made in this case is $33,000 for counts 1, 2, and 3. I have to set a bond amount for 4. I could just do a whole new bond order. I'm not gonna make it for less than whatever Judge Manning did. And so maybe your request would be figure out how to spread 33,000 across all 4 counts.
Yes, that probably would be the best way to do it, I suppose.
Okay, and it's just a new bond order because he just never made this bond because he couldn't, even if he had $33,000, because he got sent to Gwinnett and no one was, that's mistaken?
Actually, he made the bond.
Oh.
He paid the $33,000.
Oh.
Immediately shipped out to Gwinnett.
Oh,
Gwinnett had a hold on him.
got it. So the reward for posting the bond was getting shipped to Gwinnett.
So yes, that's why we're not asking for any additional bond.
Okay,
But although I do think you're right, an OR bond is
yeah.
not allowed on this particular charge. But yes, we'd be asking that the original bond be reinstated, which I believe it already was. And then yes, as far as this bond goes, we just get the lowest possible one we can since.
Okay. Ms. Nix, bond was signed, as I mentioned, by Judge Manning in January of 23. A year and 2/3 have gone by. Have there been things going on in Mr. Craig's life that make you think that that bond doesn't make sense anymore? I mean, you may not have liked, not that it was your case, 33,000. It was no bond, and then it got reduced because he hadn't been indicted. A bond had to be set. It was originally 45,000. He couldn't make it, and Judge Manning knocked it down to 33,000. And apparently he made that and went to Gwinnett.
Yes, sir. So the defendant has 2 prior felonies. One I mentioned earlier, which is the robbery from Gwinnett. There's also a attempted armed robbery from DeKalb from 2010. And the defendant was released from Fulton and brought over to Gwinnett in, looks like, February of 2023. He was, in air quotes, arrested because it's a jail case. He was charged with a prohibited item by inmate. Incident date is October 2023, and that is still pending in Gwinnett. So there have been additional felonies since that bond was set. They happened in jail, so they didn't exactly happen while he was on bond, but he was on bond. He just had to go to another jail.
Right.
based on the defendant's history and the facts of this case, along with the additional felony, the state's going to ask for something higher than the $33,000 that he made prior.
Okay.
So yes, we of course respond to that the previous court decided that 33,000 was enough. Since this happened, he's been in jail the entire time, so he hasn't been outside. Nothing has happened that would give the court a reason to think that, well, now he's a bigger threat to society. Now he's a bigger reason to run away than he was when he came in here for that first bond hearing. So I think there's no justification at all for raising the bond from that, unless, again, the minimum amount, I think, would be the only thing that would be justifiable to raise it to at this stage. Especially
what about, I thought Ms. Nix just said there was some situation there are new charges in Gwinnett. The prohibited items past a guard line.
I'm not familiar with anything that's going on in Gwinnett. That's not to say it didn't happen, but are you currently looking at a new charge in Gwinnett?
So I don't be able to back you.
Okay, yes. So he does have something in Gwinnett County.
Right. That occurred since he made bond here and got shipped over to Gwinnett. He ended up having, as best I can tell, contraband at the Gwinnett County Jail.
It sounds like it, yes.
Okay. All right. Do you know if the bond that Mr. Craig made is still a good bond? Like the bonding company hasn't come off it? There's a $33,000 bond out there.
No, they've not come off of it. No, still good.
So I don't know enough about how bonding companies work. I need to set a bond for count 4. Would I just set an independent bond? And Mr. Craig could find a bonding company that would do that? Because what I want to avoid, I have a figure in mind that I would set for all 4 counts. That would be more than 33 because we're starting at 33 and the count 4 has to have a dollar amount attached to it.
Yes.
What I don't intend for Mr. Craig to have to do is get another bond in that larger amount. So just hypothetically, let's say I set the bond at 40,000. I don't expect him to have 73,000 worth of bond out there. And so I just don't know how it works with bonding. If, let's say he was using Second Chance, if Second Chance would say, you already have a 33,000, we're going to redo the paperwork. And the judge added $7,000 for this gun count. And so our new financial arrangement is for that additional $7,000, which is $700 or whatever they decide. Do you have a sense? I mean, you work on the criminal defense side. How do we engineer this so that if I say, you know what, your total bond needs to be X, Mr. Craig doesn't have to get 33,000 all over again, plus the increment.
Right. Oh, well, it just seems to me that setting, as you say, an independent bond for the 4th charge, when you're asking that, I'm trying to think of how a bonding company typically would work, but it seems if they haven't come off of it yet, then setting the independent bond, an independent amount for the 4th bond, that would be probably the safest way to go here.
Well, that might be safe from the bonding company side. I worry a little bit about how the jail would process it because they're 2 different bonds and how do we match this up? My thought is maybe you or some other representative of Mr. Craig should talk to the bonding company that he already has to say, how do we do this? Because the judge is willing to set a total bond that would include the original 33, and then it's going to add a little bit more for the felon in possession of a firearm count. And the bonding company may say, have him set it at 40. You don't need to worry about the first 33 because you've already done. I just don't know what the bonding company is going to say. And that's not my conversation to have with them. One of the 2 of you would have that conversation. And then you can just send Ms. Nelson an email saying, this is the way we need to do it. A standalone bond for count 4 or a new bond order. Don't change the dollar amounts for those first 3 counts because they're already set. And then add that additional amount for count 4. And then Mr. Craig's bonding company will say, hey, the additional money we need is just for count 4.
We did what you just suggested. And we spoke with Second Chance. That's who I bonded out with, Second Chance. And we spoke to them about the additional charge. So, and they said just get a bond set and just need a number. We just need a bond set and they'll bond me out because we already paid the 33,000.
Okay, so I'm going to have you, Mr. Wilson. It may be that Oh, Ms. Nelson is saying release you on the original bond and then do a new bond order just for count 4. So we're gonna try that.
Yes.
If that doesn't work, in other words, he's stuck in the jail, let Ms. Nelson know. We can fix that part. If for some reason that doesn't work with second chance and it's like, we don't want 2 bar, we want it all in one. I'm happy to then do another bond order that just adds it all together into one bond order.
Okay, I think that could work.
All right. There need to be conditions on the bond. We're gonna start out with an ankle monitor, county funded, just because you haven't been out for a while. I need to make sure you're sticking around.
Okay, I'm on ankle monitor right now for the original 30,000 too.
You have one on your ankle?
No, that was the
Right.
condition from the first.
So I'm keeping that condition in place. So you'll get a county funded ankle monitor when you're released. That stays on at most 6 months unless I see some need to extend it. It can come off sooner if everything is going well. So that's a conversation for you and Mr. Wilson. If after 3 months, like I gotta get this thing off, I can't get a job, everyone sees it and they don't want to talk to me. But given the seriousness of these charges, and your other act, we're gonna start with an ankle monitor. And we will, where are you gonna stay when you get out?
With my wife, I said, 150, no.
Is it a wife or a fiance?
No, we've just been together a year, so.
Okay, it feels like a wife, but you're not married. Okay, do you have kids?
Yes,
How many kids?
1,
How old?
15.
15, boy or a girl?
Boy.
Okay, so you haven't been home for your son for a couple years.
Yeah, it's 2.5 years.
Is he doing all right?
Yes.
Okay. So I need an address because that's where you'll need to stay while you're on bond.
115 Wood Trace, Riverdale, Georgia, 30296.
Fruitwood Trace.
Apartment B.
Oh, all right, apartment B in Riverdale, Georgia. Is that Fulton or? Okay. 115 Fruitwood Trace, apartment B. And who lives there?
Kosha Akika.
I don't need the name, but that's your fiance? And what about your son?
He's there too.
Okay, is that it?
That's it.
So the 3 of you will be there. All right. You're gonna start out with a curfew of 8 PM to 8 AM. We can adjust that if your lawyer can document that you got a job and you happen to have the night shift and you're working at a place where it's 6 PM to midnight or something. We can move the curfew around, but for now, you're at home at night. But at 8 AM, you can be out and about. What other conditions? The bond that Judge Manning set, no weapons, you can't anyway, you're a felon. She had a 24-hour, stay away from welcome food. So that'll still be there. Your original bond, stay away from 1975 Campbellton Road. That's the convenience store. Wow, they took a long time to indict you. Okay. Any other conditions?
No, I think that's enough.
Okay, I'm gonna set a bond of $5,000 for count 4. And I'll sign a separate document for that. It'll have the same conditions in it. It'll add the curfew. This is a slightly different curfew. I may have to amend this other bond because it's not a 24-hour curfew. And it's gonna require you to live at that apartment B at Fruitwood Trace. If for some reason you all need to move, you have to clear that with pretrial services. You'll be subject to pretrial supervision. It's kind of like probation. They check in with you from time to time, or you check in with them. Just gives everyone a comfort level that you're doing okay. You have all the discovery in the case?
He has just sent everything over to me, yes.
Okay.
But yes, I should have.
What else remains? All right, so final plea is on December 3rd. So we'll see what happens. Ms. Nix, anything else in Mr. Craig's case?
No, sir.
you will in the next 2 weeks get everyone additional information about the Gwinnett case.
Yes, sir.
Excellent. Mr. Wilson, anything else on behalf of Mr. Craig?
Nothing else for now.
So, Mr. Craig, just so you understand the timing, assuming you have no other holds, I'll get that bond for count 4 signed today or tomorrow. Your family will do what it can to post it, and then you're out. You have business in Gwinnett still, so make sure you're taking care of that as well. Officer Evans, did you need anything about Mr. Craig reporting? He hadn't been able to report for a long time.
Thank you, Your Honor. Mr. Craig, if you can contact Officer, one moment.
Mr. Wilson, you may need to write this down for him.
Officer Blake, and that's contact number 678-426-0615 within 48 hours of your release.
Give me that number one more time here.
It's 678-426-0615.
Okay.
And if you're not able to reach Officer Blake within 48 hours, you'll report to 276. That was 276 Memorial Drive, Southwest Atlanta, 30303. And that's within 48 hours of your release. Failure to do so may result in a warrant for your arrest. Do you understand, Mr. Blake? Mr. Craig?
Yes, ma'am.
Good luck to you. Thank you.
All right, thank you.
And Mr. Wilson, you should check your email. Apparently, Ms. Nelson sent you something in connection with this case.
Okay.
All right?
Right. Do I need to write up that bond order or?
You do not.
Okay.
We'll take care of that.
Thank you very much.
Okay.
And may I be excused?
Yes, sir.
We can't get back there and talk with her.
Mr. App, good afternoon.
Good afternoon, Your Honor. Good to see you.
Good to see you. You should stay there. We got a couple other things. I just wanted to make sure you're not expected back in 1C.
I have an associate sitting in.
Excellent. Okay.
He can be here, so I can be here today for you.
Good. I think we're taking one plea and then we're going to talk about Mr. Logan's very troubled ankle monitor.
Right, and then I have.
Is he here?
He is here.
Good.
And I'm ready to go to get another case off your calendar, that's on your calendar.
Who can say no to that? Does the prosecutor know about it?
I think so. We got a notice to appear today. It's Andrew Robita.
So what I've got for you, Robita is the plea.
Yeah.
And then Logan is the bond modification.
Correct, and I'm still working towards resolving Mr. Logan's case.
We should.
I think we might.
Yeah, because he's sort of last man standing. There's someone in the wind, someone already pled, but it takes two. So is that your case now or did Ms. Clark keep it?
It is mine.
Okay.
I am waiting on a little bit more information from the detective.
Okay, I'm not pressuring you on Mr. Logan. I just wanted to make sure we have the right people to keep that dance going.
If you come up with more and better discovery, I'll be happy. It's resolved quicker, but.
All right. We'll get to that. All right, I just want to make sure we were good. I think I need to talk with Mr. Williams now,
Perfect, Judge.
since we're tying up two public defenders on that. And then you're ready to go on Mr. Vega?
Yes.
Okay, good. Was there anyone else here? So we've got, I think that's it. We're going to talk about Mr. Williams, Mr. Vega, and is Mr. Robita here? He's here. Great. Okay, we got everyone. Oh, there's Miss Peterson. Like Miss Peterson was here?
I just disappeared.
Did you get the copy of the letter?
I did, Your Honor.
Okay.
Williams.
He can come right to the podium.
That's what.
That's a discovery.
Oh, yeah.
Yes, for it. Yeah, Bob.
That's the discovery? All that? I'd just leave it on the desk right now. Hey, Mr. Williams.
How are you?
I'm okay, sir. So let's turn to your case. Good afternoon. You were here in theory to talk about final plea, but I got a letter from you.
Yes, sir.
You have very good handwriting, or someone on the outside has good handwriting for you, but it's,
Oh, no, that's fine.
it's very, very legible. In your letter, you asked to have your relationship with Ms. Wood, the lawyer-client relationship, ended. So we need to talk about that.
Yes, sir.
You also asked at the very end for me to recuse myself. We need to talk about that a little bit, but I want to stay focused on the attorney concern, because that's a concern you had last time we met.
Yes, sir.
And I encouraged you and Ms. Wood to see if there would be some meeting of the minds. Sounds like there wasn't. But I also know Ms. Primovic, who's here now too, spent a little time talking with you. And so I just wanted to take your pulse on where you think you are in terms of representation, because like I told you before, you have three options as a criminal defendant. Always option one is any lawyer you can afford, but plenty of people unfortunately cannot afford a lawyer. That moves you then to the last two options, one of which is appointed counsel. So a very experienced person who every day of the work week is working on criminal cases, representing folks charged with serious charges. So that'd be Ms. Wood and her colleague, Ms. Primovic. And then option three, which I always try to discourage people from, just because it generally doesn't go well, but you have an absolute right to, and that's you are your own lawyer, self-representation.
I understand.
And it sounds like, given your financial situation, you're in category 2 or category 3, that it's not likely that you're going to be bringing in a lawyer that you or your family has been able to hire. Is that correct, or has that changed?
That is correct.
Okay, so then we're down to you figure out a way to work constructively with Ms. Wood and or Ms. Primovic, and I don't decide if they're going to do a partnership or if Ms. Primovic is saying, I'm willing to work with Mr. Williams, that they would work that out, but it would be, I'm going to call it that team. Or if instead you want Team Williams, in which case we have to have a discussion that we probably won't have today, but it's called a Feretta hearing, where I talk to you about all of the disadvantages of self-representation.
I understand.
I'm sure you do, but we have to make it on the record so that 6 months from now you can say, judge didn't tell me this, judge didn't tell me that. But I always end it with, it's your decision and not mine, because it's your case and not mine.
Right.
So you may decide that the way the things you want to be heard are going to be heard is if you represent yourself, because that's usually the reason I end up getting from someone who decides to represent himself. It's not, I know I'm smarter than my lawyer. You may be smarter, but you're not a lawyer. And so you don't necessarily have that skill set that Ms. Wood unquestionably has, and that I know Mr. Primovic has. But there are sometimes things that a defendant says, the only thing I want to tell the jury, my lawyer is saying that's a bad idea and I won't do that. Well, then I need to do it, meaning you need to do it. Okay, then that is sometimes why people choose to represent themselves. Every once in a while, you get someone with a wild hair saying, I'll do the best job. All right, good luck. We'll see how that goes. But it's not my job to decide that. It's yours. And we're getting preciously close to your trial. So I need to know what it is you're thinking you want to do.
Right now, I thought very seriously about what the choices that you gave me representing myself. No, I don't know the law. And I wouldn't dare step up in here and try to pretend like I do. Okay. But I did ask Ms. Woods if I chose to keep her on as my counsel, is she ready for trial? She said, no, well, I'm not. I don't think it's a wise idea for me to represent you.
Okay.
Okay. But at the same time,
But that's different. I'm sorry to interrupt, but I'll let you finish. But if, and I'm going to engage with Ms. Wood in just a minute, but if she said, Judge, I can't tell you why, because it's privileged. It's the conversations Mr. Williams and I had. But if she said, I shouldn't stay on the case, that's different. And I need to honor that request, because she'd be saying that because she will have a reason why she doesn't think she can zealously advocate for you. And she doesn't need to disclose that to me, because it may be the byproduct of you confiding in her things about your case. It's okay, now that I know that, I've got an issue. I don't know that's what she's gonna say. That's what you're saying she's gonna say. And ready, and I don't think I can represent you, are two different things. If Ms. Wood said, I'm not ready for trial, the simple solution there is you ask for a continuance. And I would find out from her, well, what do you need to be ready? Well, I don't have from the state this, or we're trying to hire our own DNA expert and we haven't been able to find the right DNA expert yet. Okay, well, we'll work through that. That's different from ready or not. There are some reasons why it's not appropriate for me to continue to represent Mr. Williams. That's two different things. So I will hear from her on that. Assuming her answer is not, I should not represent him, but it's either I need a little more time or we're good. What is it that you would like to see happen?
I just want to be treated fair. I want a fair trial. That's it.
Okay.
I want the proper work done in my trial, investigative work, everything that I'm supposed to have, my civil and, constitutional rights to be fulfilled. That's all I'm asking.
All right.
It's not a lot.
It's a reasonable request.
That's all I asked for.
Okay. Well, let me hear briefly from either Ms. Primovic or Ms. Wood as to what they think is happening on the defense side, so I can figure out what we're doing next. I'm happy to hear from either one of you.
Judge, I'm happy to keep working on this case. I do think there are some big hurdles for Mr. Williams and I to overcome, but Ms. Primovic has graciously offered to work with us. And so that's where I am.
Okay. And Ms. Primovic, you've got the capacity to support Ms. Wood's work in this, because I know you get pulled in lots of directions, whereas Ms. Wood, also very busy, is focused on cases in this division.
I do, Your Honor. I should be getting ready of a couple murder cases at the end of this month and the beginning of next month.
Okay. So, Mr. Williams, it sounds like Ms. Wood and Ms. Primovic as a team are prepared to continue to represent you. It also sounds like there remain some gulfs, some differences. I want to manage your expectations a little bit, because I don't know, when you say, I want the investigative work to be done, the things you're entitled to. I agree, you're entitled to things. But what you aren't entitled to is someone doing the impossible. And I don't know what it is that you think ought to be done investigatively, but you know that both cases, your case in chief and the 413, that other act that I've ruled is going to come in at your trial, those are very old. And so just as an example, and I'm making this up, I don't know what you have in mind about the investigation that needs to happen, but we both, you may have already known this, I learned at the hearing on the 413, that other act, the case that was indicted and then dismissed, that the place where it happened doesn't even exist anymore. And so if an investigative idea is, hey, we need to go take pictures of the crime scene, well, you could. It's a Walmart parking lot now or something. I'm not remembering exactly. I just know that that detective who came in said, that doesn't exist anymore. That doesn't exist anymore. Because of the passage of time, finding witnesses and sort of recreating the circumstances of either your case in chief, which is also kind of old, but not nearly as old as the other act, that's not something anyone can do. So I just want to make sure that as you are sharing with your lawyers, both of them, hey, I think we should do X or Y, you're being realistic in those expectations, because finding people after X years is hard, after Y years is even harder. And that's just the nature of the two cases you've got because of the DNA situation.
I understand. But
Okay.
they found her and she was still around.
Yep.
I'd had witnesses in my case. She got on stand and perjured herself. Right in front of all of us.
Okay, that's where it would be, in front of all of us.
Yes, okay. She picked me up and took me to some person's house.
Okay.
With another woman. Okay.
So
and I
there
know
are
that.
witnesses out there. This other woman, do you have a name? You don't need to share it with me.
Her name is Betty.
That's all you got, is Betty.
It's all in here.
Okay.
It's all in here.
All right.
Everything that I was telling you that day, it's all in here.
And that is your envelope of, hey, I've got some leads on things?
Yes, sir.
Okay.
Yes, sir.
All right.
Yes, sir. Now,
So, go ahead.
excuse me, this other act, I asked for a picture of this person or, so-called alleged victim. I never got it. The lady that y'all brought up in here, that's not the lady I was with.
Okay.
And I told my lawyer, I'm like, who's this? But she didn't say anything about it. So I'm like, okay, well, if it's like that, I really don't need you on me,
So I think we touched on that a little bit because you were getting a little agitated at the end of that hearing.
Yeah, I
that
was.
hearing wasn't necessarily the forum for Ms. Wood to share with the state, hey, actually, I got to ace up my sleeve because my client is in a position to say, that's not even the right, you didn't even bring in the right person. And that may be something that Ms. Wood, one, needs time to verify. And then two, doesn't necessarily want to disclose it early on. You save certain things for trial because it doesn't sound like your case is working out short of trial. This is the kind of thing, given what the state's offer is, you seem to want to have a trial on it. So you should talk with your lawyer with an open mind rather than an accusatory. Why didn't you do that? I would have done that. Well, but that's the difference. As you acknowledged, man, I'm not a lawyer. And so I would have gone in guns blazing. And maybe that's not the right strategy of a seasoned litigator, which both these women are.
I understand. I gave her the information. I didn't come at her like that at first.
I'm not suggesting you came at her like that.
I'm just saying when I did, and she had this strategy, she could have informed me. That's all I asked.
Okay.
And that was my beef. How come you didn't let me know? What type of strategy? I mean, where are we going? How, because I told her things in confidence.
Right.
And I didn't get any feedback from it.
Okay. Well, maybe that's an area where collectively Ms. Primovic and Ms. Wood will be able to, since the two people
I
working
look
on
forward to it.
Yeah, having more open channels of communication. What we need to do today, the last thing two more things we need to work through today, because I'm going to table Mr. Williams is going to represent himself for now. You can always come back to that if you have a change of heart. But for now, I think we're going to go with the team approach. We need to talk about your final plea rights. And I need you to let me know if you are going to expand upon this recusal piece, because what you've set forth isn't an adequate basis to recuse.
Let it go.
Okay.
I'm gonna, go with what you recommended.
I'm not recommending me or any other judge. All I'm saying is.
I'm not talking about the judge. I'm talking about the counsel.
Got it. Okay. Your final plea today is the last day you could enter a plea in your case and withdraw that plea if the sentence I gave you was more than what your lawyer asked for. That doesn't mean a whole lot in your setting because the mandatory minimum is so high here. Unless the state was offering to reduce the charges to something where there's some give and take in there, the whole final plea discussion doesn't mean a lot. But we need to have that discussion anyway. That's just sort of the sequence of events. You reach a point where there's this deadline that if you want to enter a plea but have the ability to say no thank you when you hear the sentence that I impose, that's up through today. After today, you can still plead. You could decide before the jurors are seated, you know what, the more I think about this, they had offered me X, I'm going to take that. Let's just resolve this with some certainty. All that's different after today is that plea that you enter, you don't get to back out of it if the sentence I impose is different from what your lawyer asked for. So let me just put some fake numbers around it. Hypothetically, state, and again, it doesn't work with what you're charged with because there's that big mandatory minimum. But let's just use those numbers. The least your lawyer could ask for is 25 years to serve. The state could ask for more. And so today the state says, gosh, not only is there this case, there's that other act. And so, Judge, we think you should sentence Mr. Williams to 40 years. And Ms. Wood said, 25, you need to give him the minimum. Here are 8 reasons why that's too much, but you can't go below the minimum. So, Judge, we recommend 25. So I've got 40 from the state, 25 from your lawyer. If I were to sentence you to 26 on up to infinity, you could back out of your plea today because your lawyer asked for 25 and I gave you something more. What changes after today, if you say, I'm going to trial, which is fine, is you can still plead. And if it's those same numbers, 25 from your lawyer and 40 from the state, and I hear everything and I say, you know what, I think 30 is the right number. That ends up being the right number because I'm the judge and I do the sentencing. And you don't get it back out and say, nope. My lawyer said 25 and I'm not happy with 25, but I was willing to take that rather than run the risk of going to trial. And
I'm going to trial.
Okay. That's what I thought, but I needed to have that exchange with you so that you understand if something changes and in a week you say, you know what, I want to work this out, get me the best deal you can. That is what everyone will recommend. It doesn't bind me. And if I were to sentence you to more, that's your sentence. Just like if you go to trial. So now we're just dealing with what happened at trial. If you're found guilty at trial, it's a big if, but if you are, you don't get to back out if you don't like your sentence. Okay. I figured you did, but we have to have this conversation with everyone who is on that calendar. Okay?
Yes, sir.
So you're going to try working with Ms. Wood and with Ms. Primovic. You know how to reach me if there are concerns. Let me know. Start with them before you write the letter and say, hey, I feel like I'm not being heard. Why haven't you found Betty? But if they tell you we have been in the streets hard and we can't find Betty after X years, that's a possibility too. But you may have 19 different ways they can find Betty. Talk to this guy, talk to that guy.
Betty is her friend. Okay. The witness that came in for me, her name is Val.
Okay. So then it's Val they should find.
Either or. Betty can verify that they picked me up.
Okay.
And she was not alone. She was with someone.
Got it. Betty could be helpful. Val could be helpful. But I trust you appreciate if the assignment is Primovic, Wood, there's a woman out there named Val. Go find her.
What about the other case?
What about what case?
The other case, the other act.
The other act. What about it?
I still haven't heard anything about it. I'm waiting for the discovery.
So see those folders right there? Those are for you. That's discovery.
Okay.
And I don't know what's in there, but when I was talking with Ms. Primovic and Ms. Peterson about the case, Ms. Primovic said, we've got a lot for Mr. Williams to digest, and that's that. So
fine.
There you go. It's Christmas early for, it's not going to fit in your magic envelope. You're going to need a different envelope.
That's fine.
All right.
Yeah.
There we go. Thank you, Ms. Primovic, for all that paperwork.
Yeah.
Thank you, everyone.
Thank you both.
All right, let's do Mr. Vega, please. And then all that's left is Mr. Apt's stuff, I think.
And ever so briefly, Your Honor.
Yes, ma'am.
I know that there is a trial calendar on December 5th potentially. So I didn't know, is that kind of getting, Mr. Williams getting further notice on that one, or?
Let me look.
And I know this sounds completely ridiculous.
Nope, go ahead.
But I did just get a juror summons for that week.
Me too.
Really?
Yeah, man, I had a juror summons like 3 months ago, but they reset the wheel and I got hit. Come on, what?
This is actually the first time I've ever in my adult life gotten a juror summons.
It's important public service. You, however, will be exempted or deferred if your case is going here. You won't lose the opportunity to serve as a juror, but
And I don't want to lose the opportunity because I'm actually very excited.
good, but you'll be deferred. So it doesn't mean that you get, it just means they're gonna give you a new date outside the range, if that's how all this plays out. Mr. Williams is currently on that December 5th trial calendar. December is a little murky as to how it's gonna play out, but it's possible there would be a trial then. And if that collides with jury service, I will manage it so that you get bumped out into January or February. Okay?
Thank you very much.
You're welcome.
Was that Mandy's?
Yes, ma'am. All right, Mr. Vega's already up there. Let's get on the record in 24 SC 002512, State versus Vega. And Mr. Vega is charged, where are all my calendars? It's a laying drag situation. Did it before, did it now is basically the mechanics we're looking at. Here it is. He's charged with false imprisonment and fleeing and attempting to elude. There was a high-speed chase away from GSP, and there was a little guy, as in a minor, in Mr. Vega's car, in this case in chief, who really wanted to get out as Mr. Vega was trying to get away from the Georgia State Patrol, who used these pit maneuvers, whatever they call them, to pull him over. And apparently, there's a previous reckless driving case. That's my synopsis, but it's your notice, Ms. Nix.
Yes, sir. So in the case before you today, the defendant was laying drag and officers attempted to make contact with him while he was laying the circular drags and he fled. The defendant was driving recklessly and fled from officers. As you stated, there was a passenger who was in the vehicle with him who requested to get out and the defendant refused. That occurred in May of 2022. In June of 2023, the defendant did the almost exact same thing in Gwinnett County. It was another instance where the defendant was laying circular drags in an intersection. And when officers approached and attempted a traffic stop, the defendant fled from them, reaching speeds of over 120 miles per hour. That incident and the arrest in that case actually made the news. I provided the defense counsel with a link to that news story based on the fact that this is the same incident. The only real difference is the other person wasn't, or we don't have evidence that the other person, if there was another person in the car in the Gwinnett incident, asked to get out. The state intends to introduce that for purposes of motive, intent, identity, or absence of mistake. This is an incident that occurred after our case, but it is the same MO, same general facts. And so the state intends to use it to prove identity and motive, intent, and absence of mistake.
Okay. The Gwinnett case, what is its status now?
It was indicted, and it has I think it's still pending. I think arraignment occurred recently.
Okay. Well, I remember, Ms. Wood, is there any effort to resolve these together? Are you in touch with anyone in Gwinnett, or it's not, thus far, it's not working that way?
Not yet, Judge.
Okay. So the proof of the Gwinnett case, one, there is an indictment, but it's not a plea and conviction. But it sounds like a lot of this was caught. Was this also Georgia State Patrol or was this Gwinnett Police?
I believe it was State Patrol. But there are also videos from, it was Duluth Police Department.
Okay, but dash cam, the usual.
Yes, and there are citizen videos that were provided to the news station
Okay.
of, not of the defendant's face, but of the cars laying drag in the intersection.
Okay. You've offered up 4 purposes. I want to talk about each of them, just questions for you. And then, of course, Ms. Wood will have an opportunity to talk about this. So lack of mistake or absence of mistake, to me, the logic of that is complicated because your other act happened afterwards. And usually absence of mistake, you're like, look, he did it before. Let's just take your armed robber guy. He did it before. He knows you pull a gun on someone, give me your stuff. That's not a purchase. Or he had held cocaine before. And so when he said, I thought it was baking soda in the case in chief, but this is something that happened after. And so to me, it seems like absence of mistake would be a basis for a Gwinnett prosecutor to get in your case in the Gwinnett case.
So my logic there is that, when I've been driving, I have not laid drag in the sense of laying drag for criminal purposes, but, I've had to stop or maneuver quickly and have left tire marks. And so we would intend to use it, lack of accident or mistake, to say that he was laying drag on purpose because he has done it other times. So he knows that that's what, that he's doing it on purpose, and not that, he was just maneuvering around, I don't know, something in the street, and that's why the drag was laid.
Got it. Okay. Identification. Is there some dispute that Mr. Vega was the driver in the case in chief? Was he not? As I understood it, they pinned the car against something and he was the driver. The little 15-year-old was in the back. I think there may have been another passenger as well, but it was the little kid who was saying, I thought I was going to die. I told this guy to stop, let me get out. But it doesn't sound like the defense is, you got the wrong, 3 people ran from the car and you're accusing my guy of being the driver. It was this other guy.
There isn't much of a dispute who the driver was, but since there are other people in the car, it's
You never know.
I have seen people, defendants in the past, try to say, no, we switched around. It was actually that guy driving. I was just in the in the driver's seat.
In the pool trial, it was during the course of the collision, our bodies relocated. I was in the back seat and I ended up in the driver's seat. Okay. Motive intent, I get much more. Those would be, I don't know exactly what the motive is in laying drag, but it's the whole mindset. They kind of overlap with intent. Okay. Ms. Wood, your thoughts about the other act, proof, purpose, and the 403 angle.
Judge, we're just gonna ask that you keep the Gwinnett case out. As Ms. Nick stated, it is still pending. I do have the news article. I don't have anything more specific past that. So just based on the fact that a case was indicted in Gwinnett doesn't mean anything other than there's a case pending, which means this is highly prejudicial and is the crux of character evidence. A jury could think that, or the state could possibly argue, just because he's done it in one spot, he could do it again. It is weird that the Gwinnett case is later than the Fulton case. I still think it's more prejudicial than probative, so we'd ask that you keep it out.
Okay. So there's plenty of case law that says the other act can have happened later in time. I don't know that it's going to work for the absence of mistake part, but Ms. Nix has offered up other purposes. All right. I will take this under advisement. Is this also on the December calendar? Is that the next stop, or do you know?
This is on for next Tuesday.
Oh,
Final plea, I believe.
okay. So I should work on it sooner. All right. Ms. Nix, anything you want to add, having heard from Ms. Wood?
No, sir.
All right.
Okay.
Mr. Vega, do you have any questions about any of what we just discussed?
So right now it was just a hearing, right? Am I correct?
Like what we just did
Yeah,
today?
just
Yeah,
hearing.
I needed to hear a little bit more from the state, why they wanted to get this in, why I thought it was proper. And Ms. Wood told me why it's not.
Yeah.
I will enter an order. You will be back here on the 29th. That's next Tuesday for your final plea.
Okay.
You've heard me talk about final plea. That's the last day you could try to work this out with the ability to withdraw your plea.
Yeah.
If you didn't like the sentence I gave you. And then you are on the December trial calendar.
Okay.
So we'll see you again real soon. This motion was filed a little late, which is why we're having the hearing a little late. Normally it'd be a little further back in time, but these things happen. And I will work to get an order out on this soon so that before next Tuesday, you and Ms. Wood can talk about if that changes how you're thinking about what a trial would be like. Okay. Ms. Nix, anything else in Mr. Vega's case?
No, sir.
All right. Thank you both.
Okay.
Mr. App, in what order would you like to handle your cases?
Mr. Robita just went through that, he'll be back in a moment, so if the court will give me the choice, I will handle Mr.
Logan.
Logan's case first,
All right.
so that I'm as quickly as possible.
Hold on.
That's-
Sorry.
You're fine.
I'm about to get out of your way.
You are fine.
That's why I'm doing it. We had good look if you're part-time, they could offer you full-time. Yeah, they can do the night shift. Yeah, they offer me back, yeah.
Hours the night shift.
11 to 11. It's a 10-hour shift. It's in Alpharetta.
All right. Let's go on the record in your case, Mr. Logan. It's 22 SC 185229. And we're here to talk about modifying your bond. I have the bond modification order. Let's find your bond.
Fiance.
And how old's your kid? How old's your child? That's your child.
Yes, she's one.
All right. So you've got a $50,000 bond. You're subject to pretrial supervision. You have to live in Dallas, Georgia. Ankle monitor, a curfew from 8 p.m. to 6 a.m. Got to stay away from Mr. O'Gara and your two co-defendants. And you got to work or be in school. Mr. App, Mr. Logan has had some ankle monitor issues. I get maybe once a week, more recently, an alert that he isn't where he's supposed to be or something. I can't remember if it's outside the curfew range or it's that he's not at Scotland Drive. They're not hugely cause for concern for me, but let's work through how to restructure things so that either we don't have an ankle monitor anymore because it's been on for over a year, or we have the curfew structured so that the ankle monitor doesn't get so worried about him.
And normally, Your Honor, I would happily address any issues, but this is, I think, the first I'm hearing that there were any violations. Normally I get an email saying, hey, your client isn't where he's supposed to be.
Okay, I've been getting them, and I let the team know, let's just table it because I'll be seeing Mr. Logan and Mr. App today. And so I'll look for one of them just to let you know generically what the issue is, but give me an update on Mr. Logan and what changes you're looking for.
Well, what I was gonna say is that my client has absolutely complied with all the terms and conditions of the bond.
Scratch that speech.
I will scratch that speech, but I will say he's got no criminal history. He has a fiance and a 1-year-old child who he lives with. He is employed. He works for Amazon, and Amazon has offered to make him he's been working part-time for Amazon. Amazon has offered to make him a full-time job, but they want him to work the night shift from 11 p.m. to 11 a.m. And he would like that full-time employment, but he has so far had to turn it down because of the ankle monitor and curfew. That's the only reason we're here, Your Honor, is so that he can have further employment and improve his life and livelihood. I don't really have that much else to tell the court because, you know, he works, he takes care of his family, he goes home. I think he goes to church once a week, and that's it. I mean, that's his life. He's got a 1-year-old at home, and it's been 17 years since I've had a 1-year-old at home, but I remember a lot of sleepless nights and diaper changes and all kinds of stuff. And it's a lot of work, even if you're working a full-time job. So he's doing all that. And so humbly, respectfully, I want to keep him on the right track, and he wants to stay on the right track. And so if the court can fashion something so that he can accept full-time employment, I think that would be wonderful for him and for the court.
Mr. Logan, what is at 3607 Spring Creek Lane in Sandy Springs?
3607. That's my cousin's house.
Okay, that's where he ends up being sometimes outside the curfew range.
Is that correct?
Yes.
You understand you're not supposed to be there?
Yes.
Well,
okay. What's going on at your cousin's house? No 1-year-old there?
Oh, nah, sometimes me and my BM, we be separated and she take the baby with me. So I just go there and sleep at my cousin's house sometimes.
Oh, meaning you and your fiance are having a disagreement.
Yeah, and I don't be trying to get police involved and none of that.
That's a good choice. Okay. And so that's sort of a neutral, safe space for you.
Yes.
Okay. All right. Where in the Atlanta area, it's in Dallas. Dallas is far away.
Yes.
That's where you've been staying?
Yes.
Okay. If you didn't have the curfew and the ankle monitor, would you be staying somewhere else?
No, my job is literally in Alpharetta, the Amazon up here.
Right, but Dallas isn't near Alpharetta.
I got to make a drive every day.
Yeah, but if you didn't have to stay in Dallas, who is it? Is your fiance in Dallas?
Yes, her and my child.
Okay. Would all of you move if you didn't have to stay there, or she's staying there?
She's staying there.
Does she work near there, or that's just?
She works in Akron.
Okay. All right. Ms. Nix, your thoughts about what we do with bond? We're almost 1.5 years into ankle monitor and curfew and all that. And I'll tell you, the violations I've gotten are all, technical is the wrong word, but you're in the Sandy Springs place. It's not, you're out of state or anything like that.
Yes, sir. We do object to the ankle monitor being removed, but don't object to the shifting of the curfew so that he can have this job. I haven't received a proof of the offer of this job, but I think as long as the pretrial has his work schedule and everything, I think it should be okay for him to go do this job. And just shift the curfew hours. Sounds like the defendant is not complying with the ankle monitor. this is also the first time I'm hearing it. Sounds like he knows he's not
Gosh,
supposed
I
to.
shouldn't keep it secret from all you.
It sounds like he knows he's not supposed to be leaving where he is and where he's supposed to be, and that he's going to places he knows he's not supposed to be. So for that reason, the serious nature of this charge, we do object to removing the ankle monitor. But I guess we're not going to object to changing the curfew or like shifting it so that he can do this new job.
Okay. Let me check one thing. Okay. Mr. Logan, how sure are you that Amazon will give you this full-time promotion, shift manager, whatever it would be, but you just have to work the night shift?
Oh, well, they offered me 3 days ago, but I don't know because I work during the like part-time peak season. So I don't know if I get laid off or not. They offered me it though.
Wait, what do you mean laid? You may get, why would you be
Like,
laid
because I
off?
do the peak season, like I do like it's not full-time or part-time, it's peak season. Like they call me in, then like after a certain amount of hours, I just get laid off.
Oh, meaning this happens again and again. You work for a
Yeah.
while and they're like, hey, you've had enough hours, you're out.
Yeah.
But a few days
I'm trying to
ago,
get full-time now, yes.
a few days ago, someone said, let's stop this peak thing. We'd like to have you 5 days a week, whatever it is,
Yes.
but you have to work late shift.
Yes, overnight, 11 to 11, it's a 10-hour shift.
11 to 11 would be a 12-hour shift,
Yeah, 10.
but that's a long shift. Is it in a warehouse? What are you doing?
The Alpharetta.
But what are you doing in
On
Alpharetta?
Amazon, I'm packing the boxes and stuff.
All right, so you're zooming around, getting things and okay, one of those things where they, like, you have to fill a certain number of boxes per hour.
Yes.
And Your Honor, I apologize for chiming in, but if it would appease the court and the state, he can have the ankle monitor, he can continue with the ankle monitor. He just wants to be able to accept the full-time work and get rid of the curfew.
Right. I'm inclined to do both, get rid of the curfew and take the ankle monitor off. We're paying for it, and I don't know what exactly we're getting for it now that we are a year and a half into bond, and I just refreshed my recollection. This incident allegedly occurred now 4 years ago, so it's not ancient history yet, but yeah. So what I need is some proof that you get the full-time job. So I will, don't worry about, I'm telling you right now, don't worry about the curfew. I just want to change your bond once. And so don't worry about the curfew, take the full-time thing, but you need to get documentation that you have the full-time job. If you can get that to Mr. Apt, he will get it to Ms. Nix, he will get it to me. If I get documentation from Amazon saying that Keandre Logan has been offered and accepted this full-time job, then I will go in and do a new bond order that gets rid of ankle monitor and curfew and the requirement that you live in Dallas. You can stay in Dallas if you want. It makes sense. That's where your kid is. But given where work is, it may be that you and your child's mom decide that you should set up your own outpost in Alpharetta.
And could you get the second chance bond people to stop? Could they stop calling me too?
Well, they call you because you don't do what you're supposed to do with your ankle monitor.
That's why they call
They're
you.
doing exactly what they're supposed to do, and I'm going to keep them riding you until you get to us. I'll let them know about the curfew piece, but we need proof of this full-time employment. If you're that rock solid with Amazon, then I will adjust your bond accordingly.
All right, thank you.
Okay?
Thank you so much, Your Honor.
All right. Ms. Nix, anything else?
No, sir.
Okay. So go get that job.
Thank you, Mr.
Is he free to go, Your Honor?
He is.
Thank you. All right, let me allow.
When are you next going to work? When is it likely that you would get proof of the job?
I've been off, so I'll probably go to work tomorrow.
Okay. Sooner is better.
Thank you.
All right, Ms. Nix, are you ready for the plea in Mr. Robita's case?
Yes.
I'm almost ready, Judge. I just need
Okay.
5 seconds. All of it.
I guess I'll go up there.
Where would you like us, Your Honor?
It's really up to you. As long as Ms. Rivers can hear you, you can stay seated or you can be at the podium.
Stand in. Yes, Your Honor. No. Okay.
Why was this case moved from non-complex?
That's an excellent question. I don't know the answer.
Oh, here's the motion. Let's see what they. Oh, it was the criminal damage to property.
Because
Okay.
it was danger to human life.
I guess, but criminal damage to property first degree is not a non-complex charge, so it shouldn't have gone to non-complex to begin with. Of course, they sat on the case forever. Okay. Let me know when you're ready, Mr. App.
I am, Your Honor.
Okay. Well, then let's go on the record. This is 21 SC 178587, State versus Robita. Mr. Robita is in court with his lawyer, Mr. App. Ms. Nix is handling the case for the state. Mr. Robita, Ms. Nix is about to put you under oath. Once you're under oath, please answer her questions and mine truthfully and completely, okay?
Yes, Your Honor.
Great.
Mr. Robita, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can put your hand down. Please state your true, correct, and legal name.
Andrew Lee Robita?
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
Yes.
What is that medication?
Baclofen?
Does not taking that medication affect your ability to understand this proceeding?
No.
How old are you?
40.
How far have you gone in school?
Through bachelor's degree.
Is English your native or dominant language?
Yes.
Do you understand that you've been charged with the following offenses? Count 1, possession of cocaine, count 2, possession of Schedule 4, controlled substance, possession of Schedule 3, controlled substance, criminal damage to property in the first degree, possession of a firearm during the commission of a felony, discharging a firearm while under the influence of alcohol or drugs, discharging a firearm on or near public highway or street, discharge of firearm on property of another, 2 counts of reckless conduct, and 2 counts of drugs not in original container.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review your rights with your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your lawyer, Mr. Apt?
No.
Are you satisfied with his services?
Yes, I am.
Mr. Apt, do you waive a formal reading of the indictment for purposes of the plea?
We do.
And do you waive any null defects in the indictment for purposes of the plea?
We do.
Mr. Robita, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? As to count 1, possession of cocaine, count 4, criminal damage to property, and count 5, possession of a firearm. Actually, just 1 and 4. State recommends
You're saying that the plea is only to 1 and 4? I want to
1,
make sure.
4, 1, 4, and 5.
1, 4, and 5. Everything else is being null pros.
Yes, state will not process the rest. I just realized that the firearm during commission has to be consecutive, so.
Yep.
Let me, so to counts 1 and 4, state recommends 1 year of probation. Conditions are forfeit all seized property, including the firearms. Stay away from the incident location, which is 42113 Mill Creek Avenue in Alpharetta. Restitution to be determined, and continue the drug treatment that the defendant is currently undertaking. As to count 5, state recommends 5 years suspended with the condition of no further criminal arrests or not violating the any criminal laws.
Okay.
And state has no objection to first offender.
So it's basically 1 year of probation followed by 5 years suspended.
Yes.
All right?
Mr. Robita, do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that since there are multiple charges to which you're pleading guilty, the court also has the right to run those sentences consecutively?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you are expecting today, you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes.
Do you understand that by pleading guilty to a felony, you may not use a firearm in a crime in the future?
Yes.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty or nolo contendere to a felony in the state of Georgia?
No.
Have you ever pled guilty to a felony in any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained First Offender Act to you?
Yes.
Do you understand that if you were to violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked? You could be adjudicated guilty and resentenced up to the maximum sentence for each charge in this indictment.
Yes, I do.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by do you understand that by pleading guilty, you are giving up the following rights? The right to trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial.
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of possession of cocaine, criminal damage in the first degree, and possession of a firearm during the commission of a felony in indictment number 21 SC 178587?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for the felonies, you have only 4 years from today to do so?
Yes.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about May 3rd of 2021, officers responded to the defendant in a mental health crisis. There were reports of him shooting a firearm at a wall at this apartment complex located at 42113 Mill Creek Avenue. The defendant was found to be in possession of cocaine and was in possession of a firearm while committing these felonies. And this occurred in Fulton County.
So one gun.
I believe it was more than one gun in his possession, but just one that was used.
That's correct.
Okay.
Um,
And then a mix of drugs. I mean, there's cocaine, a Schedule 4, Schedule 3, and some things not in original containers.
Yes, there were several drugs in his possession as well, including cocaine and some, I think, prescription medications that are controlled substances.
Okay, but no one was hurt. It just was alarming and concerning.
Correct. And I understand that the defendant has gone to some drug treatment, and I've been sent some documentation of that. When this case was in non-complex, that's when this offer was originally made. I guess I tweaked it a little bit because of the firearm during commission having to be consecutive, but yes, nothing further from the state.
Okay. Let me check.
And Your Honor,
give me 1 second. Ms. Jackson, thank you for sticking with us. This is our last matter for today. Do you have any criminal history information for Mr. Robita?
He has 3 cycles. The last arrest was February the 19th, 2012 with the City of Atlanta Police Department for possession of Schedule 1 controlled substance and possession and use of drug-related objects. He received pretrial diversion for that, and he completed it. He does have 1 misdemeanor conviction that was in 2007 for DUI. Nothing in addition, Your Honor.
Thank you, and thank you for your help today.
Thank you. Have a great day.
You too. Now, Mr. Apt.
sorry, Your Honor.
That's
What I
okay.
was going to tell the court, I guess everybody stole my thunder, is that he had some prior incidents involving drugs and alcohol. After this incident, Your Honor, his family and he decided that inpatient rehab would be a really good idea. And so Mr. Robita dove into that with the full spirit and enthusiasm and effort that he had previously used to engage in drug abuse. So he did inpatient, and we've provided the state, and I'm happy to provide the court with ample documentation. He did multiple inpatient treatments at Ridgeview and then Second Chance Recovery. And then, this case is old. Since then, he's been diligently and consistently involved in outpatient treatment, and keeps up my office with that outpatient treatment and documentation of it, and checks in with us, and is really doing a tremendous job of staying clean and sober, and stays away from guns and obviously all kinds of drugs that were plaguing him before. He's 40 years old, as you heard. He's college educated. He works full time. He's otherwise an upstanding citizen and remains in treatment. We would ask the court humbly and respectfully to accept the negotiated plea. The only thing I would ask, since there's a 5-year suspended sentence after the 1 year of first offender that we're asking for, is that the court also on the sentence allow him to have a behavioral incentive date, so that if he successfully completes the probation, then he can have his record sealed.
I don't know how that works with a suspended sentence. I'm not disagreeing with you. I've not encountered that.
So 17-10-1, I believe, is the statute. I think I've got the statute right. I can look it up.
Regardless of the number.
That allows for behavioral incentive dates. And what that statute says is that the court, in its discretion, may impose a behavioral incentive date for 3 years or less if it is a non-custodial sentence and if the defendant is electing and a court is allowing the defendant to engage in the use of the First Offender Act. So
I know what a behavioral incentive date is. I just haven't ever set one once probation is out of the picture. Let's say I set a behavioral incentive date of 3 years or 2. That lands in the suspended part of the sentence. And so I guess it would really be you and Mr. Robita who'd be letting me know, because probation is going to say, we're done. He did his year, file closed, we're moving on. They wouldn't, normally it's probation is, hey, it's a bid date, we need to do something. They're not going to do that with a suspended sentence.
Correct. So, I mean, there's multiple ways the court has in its discretion and power to address this. I'm just trying to make sure his record ends up ultimately getting sealed if he complies.
Sure.
We can either come back on a behavioral incentive date that the court sets,
Yep.
or sometimes we have to file a if in my experience with these cases, if the court doesn't want to set a behavioral incentive date, then I'll still have to come back because I'll have to file a motion and then come back
Right,
down
for early termination, whatever it would
to
be.
have it, well, to have his record sealed. The record under first offender should, in theory, doesn't always work, but in theory, automatically get sealed with the GBI and GCIC. The issue we run into is having it sealed with the clerk's office here in Fulton County, the sheriff's office at Rice Street, and then sometimes whatever local police department arrested him with their records. And so to be thorough, we file a motion generally and then present a proposed order to the court to do that.
Okay.
That we then disseminate around. So I'm happy to handle it however the court sees fit. But I don't think the statute, and my point of bringing up the statute was that it would prohibit, Your Honor, from setting a behavioral incentive date at any time, 3 years or less.
Okay, got it. Mr. Robita, what do you do for work now?
I'm a business manager, product line manager of a chemical resins company,
Here in the Atlanta area?
Alpharetta. is what
Okay, what's the name of the company?
Allnex,
How do you spell that?
ALLNEX.
And if I were buying something from Allnex, what am I buying?
Resins that go on the top of a countertop. So like the top of the wood, it goes on that. It goes into automotive paints. It goes onto tires that promotes adhesion between the rubber. So it's a lot of industrial applications.
Got it. I wouldn't find it at Kroger, but if I was doing a lot of countertop manufacturing, I might be
Well-
getting it as an input.
Well, the Campbell soup can, our product goes on that. It's BPA free. So you would actually find it at the.
I find, but I couldn't buy Allnex products.
Correct.
They would be incorporated into the Campbell soup can.
Correct.
Okay, understood. Tell me what type of sobriety treatment you are getting now.
So I did 2 months of full inpatient at Ridgeview. And then did 4 months sober living after that before continuing on. And at Ridgeview, I continued in their professional care. So the Ridgeview professional programs, which is professionals, doctors, lawyers. So I continued doing that. I have a sponsor in AA. I regularly go to AA meetings. I'm well, I would say, versed in the recovery community. That's a main focal point of my life. When I was young, 14, 15, I had surgeries on my esophagus that exposed me to narcotics. So, predisposition, early age, it just caught me on a long trail that's taken many years to get out of.
Sure. Okay. Do you have any questions about anything we've discussed?
Just the suspended sentence part. So,
Your Honor, want to explain that or I can?
Well, tell me what your question is.
So it's, my understanding is that it's 1 year probation, and then after that, you can file a motion to seal my record after the 1 year.
I don't know when a motion to seal a record can be filed. Sometimes we get it right after someone takes a first offender plea.
Okay.
And so you and Mr. Apt can talk about that. The suspended sentence is a sentence, but you're not under any supervision. There's just a clock ticking in the background and you go about life. I'll be setting a condition on that sentence that you have no violations of the law. I have to do that because that's the only way I could revoke it if, heaven forbid, 3 years from now, you have a relapse and shoot up another apartment complex. Not only would you have new charges, but I could, if petitioned by the state, seek to revoke or impose some of your suspended sentence. But I can only do that if I put a condition on it. But there's no reporting while you're on there. You're not paying a supervision fee or anything like that. That's just a way that we could address new criminal activity, not only with the new charges, but a reminder that, hey, you took first offender, you got a break here. And I guess actually, and we have to talk about that with first offender, it could get a whole lot more complicated for you if I was going to revoke your suspended sentence, because really I could revoke your first offender status and resentence you as a felon, and it would be more than, it could be more than just what's left of your suspended sentence. I'll get to that. But while one is on a suspended sentence, you go about, I could set other conditions like continue to stay away from the apartment complex, and that would mean you'd need to do that. I'm not worried about that. Other questions?
No.
Okay.
I did neglect to inform the court of one important piece of information. We've left restitution open so that the state can verify, but Mr. Robita made full and complete restitution to the apartment complex for the damage that was done immediately after the incident.
Okay, great. So that's probably off the table. The state may pursue that, and they'll learn what they learn. First offender is an opportunity. You are eligible for that opportunity because you don't have a felony conviction. It means that when you leave here today, you are a first offender probationer, but if you're looking apply to a new job, go back to school, there's a background check, you don't have to say I'm a convicted felon and check that box, because you're not. You are a first offender probationer. And when your sentence is complete, all of this can be removed from your record. It may be before then, certain things can be sealed, but it's still on the record. But ultimately, if you successfully complete your sentence, expungement may be appropriate. That's a little ways down the road, but those are all the benefits of first offender. The downside that I need to make sure you understand if you are electing to be sentenced as a first offender is that if things don't go well for you, and before you're done with your sentence, both probation and suspended, probated and suspended, you have some violation of the law, you could have your first offender sentence revoked. And without a trial, you'd have a hearing, but the state's burden of proof would be much lower. I could resentence you as a felon. So there goes the, I'm not a felon. For these 3 counts, if we add it up, it gets into the double digits of time you could be sent to prison. Now, that's not likely unless what you did was real serious, and it doesn't have to be a relapse. If for whatever reason you chop your neighbor off, you have that new case, aggravated battery, and I will most certainly be revoking your first offender status and say, I'll give you 8 years on this case, because clearly it's not safe for you to be out and about. This notion of recovery is a fantasy. But if you're pretty comfortable with the stability of your recovery and the likelihood that it will persist, first offender makes a ton of sense. But that's a decision for you and Mr. App to make, not for me. Do you feel like you understand the risks and the benefits of first offender?
Yes.
Do you want to be sentenced as a first offender?
Yes, Your Honor.
All right, I will do that. I find there's a factual basis for your plea, and that your plea was knowing and voluntary. Knowing means you've understood everything we talked about. Do you feel like now that we've explained suspended sentence, you understand everything?
Yes, Your Honor.
Voluntary means no one's forcing you to enter this plea, that you've decided it's the right way forward for you. Is that also true?
Yes, Your Honor.
All right, then I'm accepting your plea. I'm sentencing you pursuant to the Probation Options Management Act, which means that for that 1 year you're on probation, if you have a real minor violation, a technical violation, that's something you and probation will work through. But if it's more serious, too many positive drug tests, or you get arrested for any, that comes back to me. Ms. Nix, is it, do you authorize someone on my office staff to sign the indictment on your behalf?
Yes, sir.
Mr. App, can we sign for you?
Absolutely, yes, Your Honor.
And Mr. Robita, can we electronically sign your name to the indictment indicating your first offender plea?
Yes, Your Honor.
We'll do that. I'm going to sentence you as to count 1 of the indictment to 1 year. 2 and 3 are dismissed. 4 is 1 year. Those will run concurrently with each other, and I'll probate that year. Count 5 has to be 5 years. It has to be consecutive to count 1. I will suspend those years. The remaining counts are dismissed. Special conditions of probation, there are 4 of them. Well, there are 3 of them. 1, you forfeit any property that the police seized from you back in May of 21. that is forever gone to you. So you forfeit that property. 2, you stay away from that apartment complex where this unfortunate situation happened. And 3, you continue to receive the addiction treatment you are. And that can evolve. It may be that you shift from AA to NA or whatnot. I'm not going to prescribe a certain thing, but you're going to need to show your probation officer that you continue on maintaining your sobriety. Your suspended sentence has one special condition, and that is that you obey the laws of Georgia and any other state and the United States. And that's just a long way of saying, if you get arrested for something while you're on your suspended sentence, I can get you back in here and see if there are going to be consequences to that. But it is not a condition of your suspended sentence that you stay away from that place. I will set a behavioral incentive date of April 23rd of 2027. That's 2.5 years from now, April 23rd of 2027. And I don't know how that's going to work, but Mr. Apt will be keeping track of it. You won't be on probation then. So the usual mechanism I'm familiar with where probation says, hey, we should shut this down. It'll need to come through your lawyer, but I'll be open to it. And I will tell you now, if everything has been going well, there's no reason to keep this hanging over your head. Okay. Ms. Nix, anything else on behalf of the state?
No, sir.
Mr. Apt, on behalf of your client? Thank you all. The 2 of you keep working on Mr. Logan. And you have a murder. You and Mr. Weinstein.
I have 40 or 50
you have lots,
murders.
but I worry less about someone else's.
Your Honor, I did just want to say one thing, just for the, I guess, public record. I do just want to acknowledge the work of the Alpharetta Police Department and the way they handled that situation. It could have gone much differently for me, and I'm very, very grateful, proud of it.
Good. Well, thank you to them. Fortunately, we have law enforcement officers who are trained in crisis intervention and not, hey, he's got a gun, so let me lay him out on the ground, because they're out there as well. So you and your family and those who care about you are very fortunate that it was thoughtful officers who came in with an eye to resolution as opposed to, hey, maybe I can get on the news. All right. Good luck.
He's a success story, Your Honor. I wish I had more, but he's great.
They're out there.
I have a murder with Your Honor.
Oh, hold on, I forgot. You got to get reporting instructions. That's Officer Evans from probation. She's going to give you some reporting instructions. She may have a couple questions, so let's pause and take care of that.
Okay.
Thank you, Your Honor. Mr. Robita, what is your current address?
1008 Wedgewood Way, Atlanta, Georgia, 30350.
I have 1008 Wedgewood Way, Atlanta, Georgia, 30350.
Yes,
Is there an apartment number or is it a house?
it's a townhouse.
A townhouse? Okay. And can I get a good contact number for you?
678-787-1012.
Okay, you're gonna report to 276 Memorial Drive, Southwest Atlanta, 30303 on November 6th, 2024 at 9:30 a.m.
Okay.
Failure to do so may result in a warrant for your arrest. Do you understand?
Yes.
Good luck to you. Thank you, Mr. Robita.
Thank you.
Thanks, Officer Evans.
Yes, Your Honor.
All right, I think that covers it. I'm going to